Lordship. Pass over for the day.
Well, I'm for a respondent, my lord. University, my lord. I'm for university, respondent university, my lord. Matter will fix on 18th July, my lord.
I'm not fixing dates.
Because my lord, there is my lord, urgency is there, not the appointment of the finance officer.
After vacation, no dates. You can make your mention. Your good name, please.
NN Upad.
On request made by any nobody, and not counsel to be petition. Release the matter after 1 week, 2 weeks.
2 weeks.
After 2 weeks. Mr. S.K. Medi, Learned Counsel. Appears for the response number.
My lord, 2-3 university.
Which university
Rabindranath Tagore University.
appears for the Rabindranath Tagore University? Yes.
My lord, I picked to mention item number 31, 32, and 33, 34, my lord. Yes,
Huh?
sir. 31, my lord. 31, 32, 33, 34, my lord. This one matter, my lord. My lord, in this case, yesterday I filed an affidavit on behalf of the governing body of the college, my lord. So it is on not record, my lord. If they can consent of the other side to list the matter after vacation.
Who is the counsel?
My lord, Zainal Abidin, my lord.
Sir, I am appearing on behalf of Janal Abedi.
Okay.
Sir, I have received their copy. Yes, I need some more time. Yesterday, my lord. So I need some more time to file reply in this regard.
Okay.
Maybe after 4 weeks, my lord.
Mr. S.K. Medi, give me the file once.
It is on not in record, my lord.
One file will do. One file.
First,
You file affidavit in,
Yes, sir. Yes, sir.
in which case?
my lord, first case, my lord.
In first case.
Yes, ma'am. For government,
Mr. S.K. Medi, Learned
government of 5 million.
I can note.
appealing for the response number 5 submits that he has filed counter affidavit in WBC number 5771 of 2023. Yesterday,
Yes, sir.
on yesterday was what date? On
2050.
on 25th of June. We issued to verify and place the same on record if found in order. Stop. Mr.
M.Z. Rahman.
M.Z. Rahman, Learned Counsel,
Appearing
on
on
behalf of
behalf
Dr. J. Affidin, Learned Counsel petitioner. Praise for how much time?
4 weeks time, my lord.
4 weeks time to file reply to the counter filed by the response number 5 in the WC 5771 of 2020.
Yeah.
Praise
Your
God.
Lordship, I'm appearing for item number 34, respondent number 3 for UGC, Your Lordship.
Mr.
PJ Das, on behalf of Ms. P. Agarwal.
P.J. Das, Learned Counsel, appearing on behalf of MSP Agrawal, appears for the UGC
This respondent,
in WBC 5457 of. Okay. Yes.
My lord.
Wait, previous your lordship. Lordship, on another matter, I'm praying for listing a WPC in the motion column, my lord. Tomorrow, my lord.
Why? What is the urgency involved?
It's related to the appointment of principal. Lordship, it is relating to the appointment of the principal, my lord. In the meantime, it will be done.
So
In the meantime, it will be done, my lord. So there is an urgency.
you filed a fresh writ petition
Yes, my lord.
Friday.
Lordship,
Oblige, your lordship.
Item number 47 and 48. In these two cases, Lordship, I filed one IA for amendment of the writ petition. Can it be taken up? Can I be allowed to call for that to IA, Lordship?
Amendment of the writ petition.
Writ petition, some appeal has been preferred and appeal has been rejected. This is with regard to the disciplinary proceeding, Lordship. So I just want to incorporate those facts.
Okay.
Oblige.
May it please your lordship. My lord, I beg to mention an item for listing tomorrow as a motion column lordship because of not getting the salary by the teacher's lordship by virtue of the one order passed by the representative regarding amalgamation lordship. So matter is pending before the higher authority in spite of that, and they are not getting salary. So I pray lordship,
Is a fresh
fresh petition lordship.
Friday.
Similar prayer, your lordship. Urgent transfer petition, my lord. In fact, some of the matters are listed before your lordship today in supplementary 59, 60, and 61. My lord, can I move it tomorrow, my lord? Urgent transfer petition, my lord.
Okay.
Oblige, deeply obliged.
May I please, your lordship? I request to mention a listing of a matter IA civil in WPC number 674 of tomorrow.
Why?
It-
What is this IA about?
It's IA about the illegality committed by the respondents I am the petitioner who was a IIT student, and your lordship has passed an order in 13.3 to allow me to appear in the exam, but they have not they have not the result was not declared. Therefore, I was not filed. On tomorrow it is fixed on the item number 40. It is fixed.
Hmm.
Kindly we take with the I. Highlights.
May I please, your lordship? May I please, your lordship? Lordship, with regards to item number 16, my lord.
Item?
16, my lord, 16.
Yes.
Lordship, though it is, has been mentioned by buyer or my lord, but unfortunately my senior is not well today, my lord, after vacation, my lord. I also inform the other side. my lord.
You mention your cases and then you adjourn it. I don't know. I don't understand.
Unfortunately, he's not well today, my lord.
Who's your senior?
D. Borba, my lord.
Okay, on request made on behalf of the Borough Learned Council for petitioner. Please after someone petition.
Sounds good.
Yeah, please, your lordship.
May I please, Lordship? In consent of the other side, I would like to mention item number 38.
Yes,
May be listed after vacation, my lord.
you are for petitioner.
Yes, my lord.
Your
I am
good
for the
name,
petitioner.
your good name, please.
Yes, Ahmed.
On request made by Mr. S. Ahmed, Learned Council for petitioner. List of the summer bill.
May I please, your lordship? I'd like to mention item number 18, my lord. With the consent of the petitioner, my lord. My lord, one affidavit filed by the petitioner, my lord. My lord, 1 week time may be granted to reply our information, my lord.
M. Katania,
So the first,
Please taken consent from me, madam.
you want time?
yes, my lord. 1 week time may be granted, my lord.
Okay, heard Mr. M. Katania, Learned Council for the petitioner. On request made by Ms.
L. Bora on behalf of M. Bora.
L. Bora, appearing on behalf of Mr.
Miss M. Bora.
Ms. M. Bora, Learned
Council for response.
Respond number 5, my lord.
Learned Council for the response number 5, list after summer vacation.
Me sir. Me sir, I have a prayer for listing of the item on 19 July 2024.
19th of July,
Yeah,
okay,
May it please, my.
yes.
May it please, my.
Yes.
My lord, item 62, my lord, I had filed one IA for implement of necessary party. But IA hasn't come up, I pray for requisition for the same, my lord, 62, my lord. I filed it day before yesterday.
Maybe it's in the defect list.
No, my lord, it is cleared, my lord, reporting hasn't been done.
Are you sure?
From what my clerk told.
If something is wrong, then I'll penalize you.
My lord. Well, I'll check and come back.
Check and come back.
Highly.
May it please the lordship, fresh matter to be listed for motion on Friday. Fresh matter.
What urgency?
Lordship, he is an assistant professor. He wants to participate in an interview conducted by the Cotton University, but the authority rejected the NOC without giving any reason. Now, the interview may be held in this month of July, your lordship.
Which date?
Lordship.
Which,
Friday.
which date is the interview?
Interview date they have not yet given, but it is in the month of July, most probably first week or second week.
Okay.
Friday, your lordship.
May it please, your lordship. Item number 65 from supply list.
65.
Yes.
Yes,
I am for the petitioner. I am seeking adjournment for the day, madam.
you want adjournment?
Yes, madam.
Okay, your good name?
W. Ahmed on behalf of the church.
Request made on behalf of the Chowdhury and the council for the petition. List of the summer vacation.
May it please lordship, item number 20 and 21 on behalf of M.K. Chaudhary. He is busy for today's election lordship, so praying for adjournment for the day.
Okay, on request made on behalf of Mr. M.K. Chowdhury, then a senior counsel for the petitioner in WC 8097 of 2022. List the matter after
Vacation.
the summer vacation.
May I please, your lordship? I'd like to mention for listing of a motion matter for Friday, my lord.
What urgency is?
The urgency is that this is the third round of litigation, my lord.
Oh.
The respondent authorities has rejected my prayer for granting one advance increment, my lord. So they are raising some new grounds and this is a settled law, my lord. Already, my lord. Third time I am filing this litigation, my
That
lord.
can come up in usual course.
On Friday, my lord, I will try. my lord.
After vacation. That can come up in usual course. There's no urgency.
Oblige, my lord.
It's okay.
May I please, your lordship? Lordship, I beg to pray for a listing of a matter also on Friday, lordship.
Why?
Lordship, the matter pertains to release of the pensionary benefits and non-payment of the salary for the month of February, lordship. Lordship, notice will go, lordship, if your lordship permits, then it's for Friday, lordship. Lordship, okay. Deeply obliged.
May I please, your lordship? Lordship, in regard to item number 54. With the consent of the other side, I pray for adjournment of the matter to the my lord.
54.
Yes, my lord.
You're petitioner.
Yes, my lord.
Your good name?
MZ Rahman appearing on behalf of J. Abedin.
Item 54.
Yes, my lord.
Javidan is respondent number 6.
I'm sorry, my lord. Respondent. We are for respondent. I'm sorry, my lord.
Have you informed the petitioner?
Yes, yes, my lord.
Okay, on request made on behalf of Mr. Javidan, then constitute respondent number 6. When do you want?
Any date, my lord. I think it
Just
must
a
be.
matter of summer vacation. Yes.
Item 25 of daily list, admission, election. Teacher, he not has the left to the port number 1 lordship because some lordship he has I will lordship can take it after some time lordship.
Okay.
Just after time, let him come. Item 1 of daily list, motion.
May I please, your lordship? My lord, in this case, my lord, yesterday, my lord, I filed an affidavit, my lord, additional affidavit, my lord, affidavit, my lord. I think, my lord, it is not in the record, my lord. So it is required to the record.
You are for the petitioner.
Petitioner, my lord. I have yesterday filed one additional affidavit, my lord, bringing some, my lord, vital facts, my lord.
With the permission of this court.
No, my lord.
And here also SSA is also an SA party. So he have to include SSA also. Because last occasion, lordship, this honorable has directed the SSA to bring some instruction to verify. Because there's some.
Okay, Mr.
Yes, I seek the, my lord.
S. A. Shikhar and the counsel for the petitioner submits that he has filed in additional affidavit. When?
My lord, yesterday I have filed, my lord, already.
On 25th. We still verify and place the same.
My lord, in the meantime, my lord, notice me go, my lord, there is a private respondent also, my lord.
You file your additional affidavit, it is not on record, now you want to.
My lord,
notice
my
to
lord,
go-
my lord.
You have to
Application, my
make
lord.
implement, you have to make application for implement of.
Last
party.
occasion, this honorable was supposed to dismiss this with a cost of 5 lakhs. That was the statement.
That is on the ground, my lord, that it is admissible or not, my lord, maintainable or not, on that ground, my lord.
Yes,
So, my lord,
That's why.
after vacation, my lord.
And let him make the SSA party. It's a very essential law to SSA.
My lord,
It's up to him, if he's
my
not
lord.
interested.
In the meantime, my lord, I will make
dismiss
party.
it.
Yes.
In the
okay,
meantime,
yes.
I will make
On last
party. my lord.
occasion, it was supposed to be dismissed.
I may be allowed to make party, my lord. I will make party in the meantime.
That is up to you.
My lord.
We have already.
Always.
Two.
Lordship, today was fixed for instruction.
Yes.
We are waiting for instruction, madam. Immediately after vacation, madam.
Have you seen the last order?
After some time, madam.
Are you still in service?
No.
You have retired?
Yes.
Yes, Divya?
Well, I have not received the instruction immediately after vacation.
Okay, but MS,
J. Rajkumari.
J. Rajkumari, learner council. On request made by STT, learner council. Standing council, elementary education department. Which the matter after the summer vacation.
Well, I'm praying for extra copy. Maybe.
Extra copy in kindly, sir. Otherwise, losing
Learner
difficult for us.
council petitioner shall furnish extra copy.
Lordship, interim order may be considered.
To the learner standing council. Elementary education, which is important. Supreme order council, department, to the next.
366 supplementary. 66. 66 material.
Six are connected.
Oh, wait. Order matter. Yes. Yes. Lordship,
Yes,
Right.
what is this IA?
Lordship, this IA is, well, Lordship, during the matter is sub judice, Lordship, they have issued this so-called notice. Lordship, in a most arbitrary manner, the director has issued this suspension order. Lordship, we kindly first take up the repetition, Lordship. The ground for suspension is stopping salary of two of my colleagues. That is the respondent number 6 and 7. Now, at the behest of the respondent number 6 to 9, my contention is that at the behest of the respondent number 6 to 9, the director in a most arbitrary manner issued this suspension order.
Where is the suspension order?
Suspension order, Lordship, will find at page. Sorry. Six, page 41, annexer 6. Sorry, man. Annexer 6, page 41. This was issued on 18th of May 2024. The allegation before issuance of this suspension order, on the same day at 12 a.m. Lordship, the director of her telephone asked me as to why I have not paid the salary of the two my colleagues, that is respondent number 7 and 8. And then I replied that I have already prepared the bill and submitted the same before the treasury officer. The transit register I have enclosed, annexer 7, whereupon it reflected that it was, Lordship, submitted on the very same day on 18/5/2024, page 49. The relevant portion of the transit register, whereby I have submitted the salary bills of two of my colleagues. It was in fact prepared on 29th of April, but because of some clarification, it was finally deposited before the treasury officer on 18/5/2024. Now,
Page
page
49.
49. This is the part of the transit register whereby I have deposited. Plus, the last column, token number is given 5138, token number 5. This is the
Where is the token number?
the last column, Lordship. 05/3128. Last column, right hand side.
Page 49.
Page 49. Lordship, right from right hand side, the last column. In the above, it is written as token number.
Wow.
The last serial number 3, 5/3128.
Yeah.
So on 18th itself, bill have been prepared, Lordship, on 29th of April because of some clarification sought from my colleagues. And ultimately, after meeting up all the clarification, ultimately I deposited the salary bill and they received the salary. Now, Lordship, as per the director's Lordship, the letter Lordship from this IA, I have ended. Lordship, you kindly take up the IA. What was the complaint? On the very same day, Lordship, they were present in the school, Lordship, and what was the complaint? IA, Lordship. If you Lordship take up IA, and next one.
1 minute. Yes, IA.
I also annex 1 page 17. This is the complaint. This is the afterthought Lordship. After issuance of the suspension order, this letter has been issued. Annex 1 page 17. On the basis of this complaint, I was placed under suspension. Lordship, Annex 1 page 17. May I read, Lordship? Most respectfully, we beg to state that we, the two contractual teachers, have not yet found monthly salary of April 2024. We already have budget for salary, but the Honorable Headmaster has not given us salary. He already has provided monthly salary for regular teachers, but he has not given our salary. I therefore request you kindly to take necessary action. Now, Lordship, before receiving this application, because these two teachers on 18/5/2000, they were present in the school. At what up to 3:30 they were present, and at what time, Lordship, they reached the director office and filed this application, that I don't know, Lordship. Now, Lordship, before receiving this letter, Lordship, this complaint, the director already issued the suspension order and it was telecasted in the news channel at 4 p.m., Lordship. And the suspension order is also, Lordship, given to me through WhatsApp number. I have, Lordship, categorically stated, Lordship, in paragraph number 7, page 10. The most arbitrary number at the base of this order. May I read also paragraph 7? Entire incident also I have narrated Lordship here. Under what context this order has been issued? Petitioner begs to state that on 18/5 at around 12:30 p.m., a phone call was received by the petitioner from the Director of Secondary Education Assam. The aforesaid mobile number is actually registered
You're reading
from page 10, annexure 7 of the writ petition.
Oh, page 10 is writ petition.
Writ petition, Lordship. In fact, it was also, Lordship, discussed in the IA also. Lordship, take up my IA also. In IA, page 10, Lordship. Page 10 of the writ petition, Lordship.
Now back to again writ petition. What is this?
Writ petition of what? Assess writ petition.
Yes,
Yes, correct. Lordship, writ petition, Lordship, take up.
yes.
Page 7, Lordship, page 10, annexure 7. Para 7, Lordship. Annexure, page number 10, paragraph 7. The petitioner respectfully begs to state that on 18/5/2024 at around 12:30 p.m., a phone call was received by the petitioner from the Director of Secondary Education Assam. The aforesaid mobile number is actually registered against so-and-so who has good relationship with so-and-so. While on call, the director asked the petitioner over telephone as to why he has not submitted the salary bill of extra teachers of the school. Upon hearing the news, petitioner was in a state of shock and immediately asked who had given her information of stopping salary of extra teacher of school. Petitioner also informed the director about telephone that after assuming the charge of headmaster with effect from 7/11/2023, he used to prepare the monthly salary bill of the teachers and unit regularly and submit the same before the concerned treasury office, Nagaon. The director also about telephone threatened the petitioner that you may be suspended from service for your activity.
The petitioner for the begs to state that on the same day on 18/5/24 at around 4 p.m., a news clip regarding suspension of the petitioner had been telecasted over so news channel on the ground of stopping salary of extra teachers of secondary education by the petitioner. Now, immediately thereafter, on the same day, the Director of Secondary Education Assam suspended the petitioner by order dated 18/5/24, pending withdrawal of departmental proceeding. The aforesaid impugned order dated 18/5/24 has been communicated to the petitioner through his personal WhatsApp number. Be it stated here that wages bill for the month of, this is important. Be it stated here that the wages bill for the month of April 24 of the extra two teachers, response number 7 and 8, are also being prepared on 29th and submitted before the concerned treasury office by token number so and so, and accordingly they received monthly salary of in due time, that is on the month so and so itself. So Lordship, from the complaint which was lodged by the response number 7 and 8, it was the ground at all is not for considered a suspension, Lordship. And before Lordship, after receiving this complaint from the director of his, no explanation is also called for from the petitioner, Lordship. And on the very same day, Lordship, already I have deposited the bill, they received salary, and thereafter also this order has been issued. And this only be issued, Lordship, at the behest of this response number 7, 8, Lordship, because they are always against me. I have narrated in my petition, Lordship, as to why they are against me, Lordship. So without any reasonable ground, Lordship, or is the use of vindictive misuse of power, this suspension order is issued, which is not sustainable, Lordship.
That will consider after we get the instructions.
Already, Lordship, they receive
They
100%.
have already issued so called.
That's
It has already been initiated.
Kindly, so
However, my instruction is that the petitioner should have preferred an appeal under section 14 of the disciplinary appeal rule 64 of the, instead of here directly approach this honorable court. So he may file an appeal before the concerned authority, where all the respondents, all the parties will be here, and he may submit his lawsuit.
that's when the, it's completely. That's when the decision of the director is itself arbitrary, Lordship, and it infringes the rights of the fundamental rights, then alternative remedy may not be preferred, Lordship, by the petitioner also. On that account, Lordship, I'm relying on some decisions, Lordship.
That is fine.
Now, this
So-called has already been
apparently, that's so.
No, why have you filed this IA?
I Lordship for staying the suspension order as well as the so-called notice, Lordship.
Why?
Because the ground for which the allegation for which I was placed under suspension, that is not at all true, Lordship. Because already they received salary.
No, they received salary after your suspension
No, on 18/5.
on the same day.
No, this over telephone, the director threatened me to suspend as to why salary I have not paid. Lordship, there is no authority to stop salary of any teachers. I have, in fact, Lordship, kindly from the transit register, I prepared the bill. My intention was, there was no intention that I'm stopping the salary. Bill were prepared on 29th April because of some clarification sought from this petition, respondent, Lordship 7 and 8.
What
It was.
Under section 14, only there is a clear provision for filing an appeal against the suspension of it. Under the discipline appeal rule. Next page is so-called Lordship. On 5, 6 Lordship, it was issued.
Have you replied to the show cause?
No, Lordship, because till yesterday, Lordship, I have not received this so called, Lordship.
Till yesterday, you have not received the.
Not received, Lordship.
But then in the IA, you are saying that you are.
Yes, it is from their instruction, Lordship, but the officially, Lordship, the petitioner has not received, Lordship.
Let him participate in the DP.
No,
and
Lordship, my
prove his
submission,
innocence.
yes, my submission is, Lordship, when the matter is sub judice, Lordship, the director cannot draw a parallel proceeding. That is number one. Second ground is that, Lordship, this order of suspension is arbitrary in nature, Lordship, without any reasonable ground. In a vindictive misuse of power, Lordship. Lordship, to that effect, Lordship, I am relying on some decision, Lordship.
Dekha, you have two options. You file an appeal under Rules 14. Before the upper.
That alternative remedy, Lordship, I may go,
Or,
but when
or
the,
we will ask them to file their affidavit and then dispose of this. No statement.
Lordship, second option is,
I cannot grant it.
Lordship is right, Lordship, the second option is appreciable, Lordship. But you see, when the order itself is arbitrary, Lordship, the face of the order,
That we
Lordship.
have to consider, that we'll have to consider after they produce the report.
Yes, for a moment, Lordship, kindly consider also one judgment, Lordship, and relying, Lordship, why, Lordship? Yes, 2013-16 SCC, Lordship. What do you see? When can, Lordship, suspension order can be issued? Page, Lordship, 147. 2013-16 SCC 147. Directly, Lordship, kindly draw your Lordship attention to paragraph, 3 paragraphs only. Paragraph 20, it will Lordship find at page 161. Paragraph 20, 21, and 22. Elaborately discuss the appeals court, Lordship, as to when the suspension should be issued, although it is in a authority, Lordship. May I read, Lordship? 163, paragraph 20. In state of Orissa, Lordship, what do? In state of Orissa versus so and
You
so,
read from para 19.
yes, during suspension, the relations,
20.
No.
Para 19.
yes,
19
during suspension, the relationship of master and servant continues between the employee and the employee. However, the employee is forbidden to perform his official duties. Thus, a suspension order does not put an end to the service. Suspension means the action of debarring for the time being from a function or privilege or temporary deprivation of working in the office. In certain cases, suspension may cause stigma, even after exoneration in the departmental proceedings or acquittal by the criminal court, but it cannot be treated as a punishment even by any such of imagination in the strict legal chains. Now, Lordship, on paragraph 20. In state of Orissa versus Bimal Kumar so court observed as under, the order of suspension would be passed after taking into consideration the gravity of the misconduct sought to be inquired into or investigated and the nature of the evidence placed before the appointing authority on and on application of mine by the disciplinary authority. Appointing authority or disciplinary authority should consider and decide whether it is expedient to keep an employee under suspension pending aforesaid action. It would not be as an administrative routine or an automatic order to suspend an employee. Now, Lordship, in my case, Lordship, it is as an administrative routine. The director passed this order. It should be on consideration and axiomatic order to suspend an employee. Sorry, it should be considered of the gravity of the alleged misconduct or the nature of the allegations imputed on the delinquent employee. The court or tribunal must consider each case on its own facts. No general law could be laid down in that behalf. In other words, it is to refrain from him to avail further opportunity to perpetrate the alleged misconduct or to remove the impression among the members of the service, and the dereliction of duty would pay fruit and the offending employee could get away even pending inquiry without any impediment, or to provide an opportunity to the delinquent officer to scuttle the inquiry or investigation, or to win over the witnesses or the delinquent having had an opportunity in office to impede the progress of the investigation or inquiry, etc. It would be another thing if the action is actuated by malafide, arbitrary, or for ulterior purpose. The suspension must be a step in aid to ultimate result of the investigation or inquiry. The authority also should keep in mind the public interest of the impact of the delinquent's continuance in office while facing departmental inquiry or trial of a criminal charge. Now, paragraph 21. The power of suspension should not be exercised in an arbitrary manner and without any reasonable ground or as vindictive misuse of power. Suspension should be made only in case where there is a strong prima facie case against the delinquent employee and the allegations involving moral turpitude, grave misconduct, or indiscipline, or refusal to carry out the orders of superior authority are there, or there is a strong prima facie case against him if proof would ordinarily result in reduction in rank, removal, or dismissal from service. The authorities should also take into account all the available material as to whether in a given case it is advisable to allow the delinquent to continue to perform his duties in the office, or his retention in office is likely to hamper or frustrate the inquiry. Now, paragraph 22 is the view. In view of the above, the law on the issue can be summarized to the effect that suspension order can be passed by the competent authority considering the gravity of the alleged misconduct.
Yes.
Gravity of misconduct, that is serious act of omission or commission, and the nature of evidence available. It cannot be actuated by malafide, arbitrariness, or arbitrary or ulterior purpose. Effect on public interest due to the employee's continuation in office is also a relevant and determining factor. The fact of the case have to be taken into consideration as no formula of universal application can be laid down in this regard. However, suspension order should be passed only where there is a strong prima facie case. So in this case, Lordship, apparently there is no strong prima facie allegation or case to initiate the or issue the suspension order. The only allegation is that stopping salary for the month of April. The bill, Lordship, I have submitted, they received salary because of some clarification.
After your suspension.
Lordship.
On the date
Not
of
after
your
suspension. Lordship, suspension order issued at 4 p.m.
It was passed on 18/5/2024.
Already before that, Lordship, I have deposited the bill, Lordship, personally went there to the Treasury office and
Can you show that?
the transit register, Lordship.
Transit register shows only this page 49.
Hmm? Yes. Page 49. On 18/5, I deposited the salary bill, Lordship, after taking the token number, Lordship, on 18/5 itself, and they received, Lordship, after, Lordship, my submission is the, Lordship,
Did you
after.
deposit on 29/4/2024?
No, this is the date of the preparation of the bill. After preparation of the bill, I prepared bill on 29th April itself. Some clarification is sought from these two, my colleague. After meeting up this clarification, finally I deposited this bill
No,
on,
what clarification?
because while I'm preparing some bill, Lordship, there is a discrepancy of the amount as per the information given by the petitioner, Lordship. So after clarification, those finally I submitted after
That
taking
was- that-
on 18/5. So apparently, Lordship, there is no strong prima facie case for suspend or issuance of this suspension order. Ultimately, this is not a case for reduction. Suppose the DP is initiated. There is no, Lordship, major punishment will be inflicted, Lordship.
My lord, the correctness of the allegations, that will be appreciated by the appellate authority, lordship.
No, no.
What is it?
Regarding alternative remedial also, I also relying the decision that my learned friend is insisting for appeal. It clearly says, the authority
That's
say,
why I've given you two alternatives.
Lordship.
I've given you two alternatives. We'll let them file the affidavit.
Or lordship may kindly direct, as we
Lordship,
have
if we
already
just-
initiated the DP. We have already issued a so call. Let him participate and
No,
let
no.
him be finished within a period of.
Lordship, it's a stigma, even if I exonerated, it's a stigma to me because I am the headmaster of the school. It's a stigma, Lordship.
What stigma?
Yes, Lordship, if tomorrow, Lordship, they found that, Lordship, there's some minor penalties imposed, it should become a stigma because intentionally, Lordship, kindly appreciate the situation. That under what allegation, Lordship, the director has issued this suspension, number one.
Let us see what the respondent 6 to 9 also says.
Lordship, I have, Lordship, already, why they are against me, Lordship, I have explained.
That is a part, that is one part of the story.
Lord.
The other part we'll see. We'll issue notice.
It will take. Or Lordship, let them file a response.
Fix it immediately after,
Fit, Lordship.
immediately after vacation on the 16th.
Okay, heard Mr. Dekal and counsel for the petitioner. Mr. SMT Chishti, standing counsel,
Second read.
secondary education submits that he has received instructions.
Yes, that I, Yes.
And prays for some time to file counter affidavit.
yes.
Praise allowed, please immediately after the summary.
On 16th,
That date may fix, Lordship.
That will come.
Lordship, date may fix, Lordship. Otherwise, Lordship.
Is the matter on
16th, 7.
18th.
18th. Oblige, Lordship.
IA,
I can remain, Lordship, because I'm not taking
I'll
consideration.
make this as a whole, lordship.
Yes. Oblige, Lordship.
Hey, I had to copy to Madrid, I have copy to an.
25.
yes, so what is this not?
But here actually on last occasion, Lordship has directed the Secretary Personnel to appear for a deliberation. In fact, Lordship may kindly have a look at the order dated this sec. The order dated kindly see, Lord. But 23, 5 order kindly see, Lord.
23?
23, 5, Lord.
There's no order of 23.
Well,
Only period malab 28-3 malab,
Sorry, sir.
2014.
sorry.
28-3 malab.
So in fact, after
What is your case?
Lordship, after Debabrata Tiwari, state of West Bengal was a Debabrata Tiwari's case. Now the position as regard the compassionate appointment is that after 10-15 years, the immediacy for appointing a person on the compassionate ground doesn't remain. So the Lordship has seen in many cases, Lordship has expressed that after 15 years, 20 years, even the appointments are being made under compassionate ground. And the Lordship has, following the ratio of Debabrata Tiwari, has dismissed some cases. And subsequently, Lordship has seen some cases are coming up after 15 years, 20 years, appointments are being made. Then Lordship has posed a query that what is the policy to be adopted by the state government in Assam in view of the Debabrata Tiwari's case, because ultimately that situation has to be taken care of. Otherwise, after 15 years, 20 years, if that is going on, the immediacy for the object of the compassionate appointment doesn't remain. That is where, my lord, the honorable court has on 2-5, kindly see, my lord, 2-5 order.
1 minute.
2-5, my lord.
One.
Lordship has indicated that why the last sentence.
Yes.
Malad has that adjourned the matter on my prayer and asks us to so as to enable him to get further instructions from the respondent authorities as to why claims for appointment on compassionate grounds are being considered after lapse of long period of time. And prior to that, the previous order. There. No, it is very nice. Indicate.
28.
28/3/2024.
Yes, sir. Twenty-three, bro. Lordship has directed us to bring the grounds why after 23 years it was considered. So, Malad, for it on that premises, Malad, Lordship has directed us to call the officers for a deliberation and what the government has now going to adopt the policy, how the government will go ahead with this. But so for the state of Assam is concerned, from 1/4/2017, Lordship, this scheme has come, that is for compassionate family pension. So now the acquisition of appointment doesn't come. As per the Oshur Pranjan case, Malad, the period of 2 years, their Lordship has indicated that if the application remains pending for 2 years and because of vacancy, Malad, cannot be considered, the application to be treated as to have spent force. But because of some circumstances, Malad, the things are going on. So, Malad, now the in view of the Devabrata Tiwari's case, the immediacy the object has to be mainly, Malad, taken care of, and the immediacy has to be seen. Otherwise, after 10 years, that if the family can survive for 10 years, 15 years, no, it is appointment.
Here is a case of 23 years.
23 years.
So what do you have to say on
The ultimately, when Malad, where the appointments have already been given, that cannot be taken back in my respectful submission. But what the state government has now proposed and what they want to do as a policy matter, Malad, that Malad, possibly they have in view of these orders, they have already initiated, to my understanding, Malad, they have already initiated some steps, Malad. They will come up with the content.
Yes, the secretary, what do you say on this? Come to the mic.
Sir, we are into the judgment of this Devabrata Tiwari case, sir. And the government is, we are formulating a policy aftermath of this order, sir. And since this order relates to, it pertains to the appointment, compassionate appointment who against people who have died long back. So since the very purpose of the compassionate appointment is not in force after 20 years. So in view of the judgment of the Supreme Court, sir, the government, state government is formulating a new policy. So we'll be formulating a new policy regarding answers as on date today, sir. We have a policy of giving compassionate pension to the
No,
person.
that we know. That you have done away with the compassionate
Yes, sir,
appointment,
yes,
and
yes,
that was on 1/4/2017.
17.
Yes.
So
Alright, that's fine.
all the claims, those are
Prior to 1/4/2017,
Sir.
what we have noticed
Sir.
is that there are many cases where the compassionate appointment, they've made the application, it is not considered for a very long period of time. then like in this present case, you have given the appointment to the respondent number 9 after a gap of about 23 years. Sir. Now that is going totally against the
Highest level.
sir, in view of the in view of this judgment, sir, of the apex court, sir. So there will be a policy very soon, sir. How long will it take? How long will it take to frame that policy? So it will go to the competent authorities, sir. The competent, including. So have you formulated the policy?
Process has been.
Process has been
I'm-
initiated,
The
sir.
process has been initiated, but while adopting the policy, ultimately it goes to the, from the initiation is at the lower level, it goes to the higher level. It
That's
takes
fine.
some time.
That
It takes
that
some
we
time.
understand.
It takes some time. But what I would humbly submit, Lordship may kindly keep the matter after a month, and let them provide the progress of the thing, what has happened.
Okay.
Respondent number 9 illegally holding this post, my lord. But I have challenged that appointment order, my lord.
When was the
At the-
appointment made?
Appointment kindly see page 56, my lord.
Lord, as regard the merit of the case, Lord, I have some limitations, Lord. I don't have that instruction, Lord. Possibly the
Page
department,
56,
the
my lord.
departmental council, they are there. Education department.
And my lord, as per record, my lord, at the time of filing application, my lord, he
One
was
minute.
also minor, my lord.
Yes. Secondly,
Page 56, annexure
56.
15.
My lord. It is the appointment order, my lord.
This is an order of September 2022.
22, my lord. And my lord, at the time of application, my lord, he was minor, my lord. Kindly see page 49, my lord. Date of application, my lord, 10/1/2000. Page 49, my lord, fourth column, 10/1/2000.
Serial number?
Serial number 8, my lord. 10/1/2000, my lord. It is the, my lord, date of application. And thereafter, my lord, kindly say page 26, my lord. In the year 2000, my lord, he was only 16 years. Page 26, my lord. It is the legal year certificate, my lord. Only 16 years, my lord.
Hmm.
I am the, my lord, eldest son of the deceased, my lord, and I approach before this honorable court, and my application is pending before the authority, my lord. In spite of that, my lord, the authority, my lord, appoint the respondent number 9, my lord.
You are appearing for?
For the respondent number 9. So what has happened here?
The notice has not gone.
Notice already issued, my lord, appears, my lord.
Notice not gone. This in the motion stage.
No, my lord, but due to, my lord, personal item number 25, my lord.
Item 25. This is an admission matter.
No, this is a motion stage.
Admission, my lord, item 25, my lord.
Okay, I'm sorry.
The only thing here, your lordship, the Devabhrata Tiwari's case came up in 2023. I'll just add to what my learned friend has said. Now, we cannot turn back the clock. What has happened? There are hundreds of cases which has come up. They have taken 10 years, 20 years, 5 years, whatever it is. It has gone. These people are already working for a period of time. This appointment was in 20. Now, what has happened, your lordship? Yes, there was a long delay. The delay was not on the petitioner or with regard to the respondent, and all. But the question is whether your lordship will turn back the clock and go back and dismiss this case. or dismiss the appointment which were made. Now the question which comes up here, so 2023, the Tiwari cases come. These Tiwari cases come, and then thereafter, after that Tiwari's case, the state has taken an initiative of I think a proposal has already been made that no further consideration will be made with regard to the appointments after a long lapse of time. So that he will produce. Now what has happened? Because of the policy decision that would be or have been taken by the government. Now what has already happened? Whether those can be interfered with. If one is interfered, your lordship, there will be hundreds and hundreds of cases which will come up, because your lordship knows that beyond 2 years, there are hundreds of cases coming up before this one. So that is the only point that I point out, is that whether your lordship will again turn back the clock and go back to all these appointments, where appointments have been made after 5 years, 10 years, 20 years, and the appointments may be cancelled. That is, yes, he may be correct to an extent that it should be stopped. It should be stopped.
Let
And
us,
we also feel
let
that
us
it
see
should
what
be
the government comes, what
Yes.
policy government
But
comes
at
up with.
this time, your lordship, the interference will be a
But Kirin and council. Stop. The secretary to the government of Assam. Personal department is personally present in court. In terms of the order dated 1960. In the course of deliberation. The secretary. Governor of Assam, personal department,
Mr. T.P. Borgohain.
that's all.
Lordship.
Submits that the respondents are undertaking a process to frame a policy in terms of the various pronouncements of the Honorable Supreme Court with regard to delayed appointment on commissioner grounds. Stop.
Delayed claims for appointment of commission.
On delayed claim for appointment on commissioner. He therefore submits that, no, he therefore prays that he may be, that the Department of Personnel, that the Personnel Department, Governor of Assam, may be permitted to file an affidavit to place on record the status with regard to the policy being framed by the government in this respect.
Not just
Stop it. The prayer is allowed. List the matter after 4 weeks.
Mother.
That's okay.
Will dispense his appearance,
At this stage,
the personal appearance of the secretary to the governor of Assam, personal department is dispensed for the time.
Date may be mentioned, my lord.
It will come up later.
Obliging.
For motion.
Lordship, kindly peruse the last order.
I have already requested my senior friend, Lordship. I need some time to get the instruction. Let it come immediately after vacation, Lordship.
KJB and council for issue. Mr. SMT Chisti and Sunday Council, Secretary Education Department. Press for another 2 weeks time to enable him to receive. Press, please not to be someone.
Highly obliged.
Kindly peruse the order, my lord. Dated 14/6, my lord. The case is the, my lord, to regularize the service of the husband of the petitioner and thereafter, my lord, compassionate family pension. In fact, my lord, the husband of the petitioner suspended in the year 2014. And this suspension, my lord, continued till his death, my lord. Is seeking, my lord, therefore, regulation of that suspension period as well as
When did your husband die?
died, my lord, on, my lord, 1/4/2024. My lord, kindly see page 49, death certificate, my lord. 1/4/2024.
2024.
And suspension order kindly peruse, my lord, page 46.
1/3/2014.
1/3/2014, my lord.
Years.
And thereafter, my lord, 50% substance allowed, my lord. And till his death, my lord, he received, the husband receiving, my lord, only 50% substance allowance and died in the year 2024, my lord. And thereafter, my lord, no step has been taken for, my lord, regulation of death suspension period as well as compensation of family pension, my lord.
Yes, Bora.
Lord, I have received my instruction, Lord. In fact, Madam, petitioner has suppressed many, Madam. In fact, there is a judgment against him. He has been convicted in a criminal case. And judgment has been delivered on 29/7/2019. He has been convicted under section 471. I'll put it on affidavit, Madam. These are all things have
You
been.
got the instructions?
Yes, Madam, but even the order I have it.
Let us. That conviction has been challenged?
Lord, sir, I don't know whether that conviction is there, Madam. Even that, my friend also doesn't know whether it has been challenged or not.
Okay, don't.
Are you aware of your conviction?
No, my lord, I have to receive instruction, my lord.
Then let him file his
My
affidavit.
lord,
Will issue notice.
my lord.
Not clear, particularly the conflict of interest. Issue notice. School education? Mr. Vicky Bora, Leonard Standing Council? Elementary Education Department, appears for respondents? 1 and 4, madam. 1 and 4. Pension? Mr. B. Deori, Leonard Governor Advocate, tenders appearance on behalf of respondents 2. Number 5. 2 and 5.
2 and 5, 2.
2 and 5, correct?
Yes.
Finance? Mr. H. Alia, Leonard
Yes,
Standing
yes,
Council, Finance, appears for respondents 3.
Only 3, my lord. 3 and my lord, 3 and 11.
There are 3 and 11, my lord.
3 and
3 and 11. And Mr. S. Bora, Leonard Standing Council,
6, 7, 8, 9 and 10.
BTC appears for the respondents
6, 7, 8, 9 and 10.
6 to 10. Stop. Notice on the respondents are complete. Stop. Mr. S. Bora, Leonard Standing Council, BTC submits that he has received instructions. And prays for how much time?
That's a 2 weeks time.
3 weeks time. File out contract. Praise Allah. Please not to do this. You take back this.
Lord.
Obliging.
6.
My lord, in this case, my lord, last occasion I was directed to bring instruction.
Have you received the
No,
instruction?
my lord, I have not received.
What is taking you so long?
I need some time, my lord.
Regarding the midday meal rice lot and their costs. Those are not giving lot to the school, offering to the school lot. So the children are getting problem. So, if they are not a short date, maybe given fixing a date, my lord.
No, at this stage, no, office may go, my lord, I will bring the instruction.
And staff also not releasing from the other blood amalgamated high school. Other it is amalgamated with the high school blood. Now it is de-amalgamated by the order of the Honorable Court,
As
my lord.
per procedure, my lord, SSA is used to deliver the midday meal.
Okay, heard Mr. Roshit, London Council for the petition. Mr. B.K. Bora, the standing council,
Elementary education.
elementary education, praise for another 2 weeks time to file, to receive instruction. Praise the Lord. Please come to summer.
May have been on a date, my lord. 17, my lord.
It will come, it will come. After summer vacation, I'm not fixing it.
17.
Seven.
Bless.
May it please your lordship. Lordship, petitioner's father died in harness in the year 2013. Thereafter, 2014, he filed his representation, lordship. And since then, the only communication he received from the respondent authority is at page 14, lordship,
Page?
14, lordship. 31,
Yes.
2017, lordship. With reference to the subject cited above, I have the honor to furnish here with the proposal for appointment as grade 3 and grade 4 category under compassionate ground quota within the jurisdiction of the Deputy Inspector of Schools, Udalguri, for the session 2014 to 16. All required particulars along with the scoring pattern matrix of the applicant is attached herewith. This is for your kind information and necessary action. This was by the Deputy Inspector of Schools. So although no attachment was sent to the petitioner, and this is the only communication. So thereafter, he visited the office verbally. He was assured that his case will be considered, but nothing has been done, lordship.
After 10 years, you are coming to court.
Yes, lordship.
Why?
In fact, because I was under bona fide hope that my case will be considered because 2017 also communication was there.
Hmm.
And thereafter also, whenever I have visited, it was, I was assured that, lordship.
Yeah, who appears?
In this case, I am appealing my lord, but my lord petitioner is praying for consideration under my lord Deputy Inspector of School Udalguri, my lord. Then my lord BTC is necessary party, my lord.
Udalguri.
My lord. Page 9, my lord, prayer portion.
Then you have to make, implement a party.
Yes, lordship will implement me. In the meantime, notice may be issued, lordship.
No, first you implement a party, then we'll issue.
And
My lord,
what,
they are the necessary party, my lord.
MST, some then the council. Praise for 1 week, 2 weeks.
and lordship, I like to draw lordship's attention. One minor mistake, typographical error. This should be 17/1/2014.
Where?
Where in the synopsis part. 17/1.
That also you'll have to file an IA for correction. Now you can't do it by hand.
What lordship?
No, whatever it is, there's already a notification. to the-
Only one numerical lordship.
You file 2 IAs. MST, some little constitution. Praise for how much time you require? 1 week?
1 week lordship.
Praise for a week's time. To enable her to file an appropriate application for improvement of necessary. I'm not saying about the correction. You file your IA on that. So, praise the Lord. List the matter after 1 week.
Obliged, lordship.
8.
And in this case, my lord, I have received the instruction, my lord. Petitioner was discharged from the criminal case on 2/3/2024, my lord. And thereafter, he approached the authority on 29 April 2024.
1 minute. You are still under suspension.
Yes, my lord.
21/3/2022.
Yes, my lord. And thereafter, my lord, I was already discharged from the criminal
Yes,
case,
that
my
will
lord.
not-
Well, he approached the authority on 29 April 2024, my lord, and the BEO, my lord, has submitted the proposal for reinstatement on 6/5/2024 to my lord, director, my lord. So it is under process, my lord.
But can he continue on the suspension?
That part, my lord, they
Have you
have not,
reviewed the suspension order?
well, that instruction I do not have, my lord, because my lord, notice has not been issued, my lord.
There's no point of issuing notice in this petition.
My lord,
You revoke the suspension order, that's all.
my lord, but they have already processed for reinstated, my lord.
We'll say,
Yes, the proposal from the district has come for restatement. It is under process in the directorate.
you have no instructions from the director?
My lord, no, from the DO, my lord.
Okay, let us see what happens. What, Mr.
AK Gupta, madam.
A.K. Gupta and counsel for the petition. Stop MSSPTL and the standing council, elementary education department submits that the petitioner approached the district elementary education officer, isn't it?
Yes, sir.
By filing an application for reinstatement on 29/4/2024. Stop. Accordingly, the district elementary education officer on 6/5/2022 has forwarded the application of the petitioner for reinstatement before the director of elementary education. MSSPTL, the Learner Standing Council, Elementary Education Department. Therefore, prays for some more time to enable her to receive instructions with regard to the process of reinstatement of the petitioner in the directorate. Praise the Lord, list after 3 weeks.
May I pray that the date may be fixed now?
It will come.
Obviously.
9.
Lordship. The petitioner is the mother of respondent number 6 here in Lordship. She is also the principal of Emmanuel English High School, Ailapur, Lordship. Lordship, the respondent number 6 applied for BA under IGNO, Lordship, and
The petitioner is the mother
yes, Lordship.
of the respondent number 6.
Yes, Lordship. She,
Oh, yes.
Lordship, she applied for BA degree, Lordship, and while applying, Lordship, she misrepresented, saying that she belongs to non-creamy layer, Lordship. And this came, as in when this came to her notice, Lordship, she informed the authorities at IGNO, Lordship, but the authorities have not considered it till date. Now, she is also working as the principal of Emmanuel English High School. At that point of time, when the petitioner applied, Lordship, the respondent number 6 applied, she was working as assistant teacher of that Emmanuel English High School. So this has had a negative impact upon the school as well as the petitioner. So now, Lordship, at this stage, I am praying that at least the representations preferred by the petitioner before the IGNO, that may be considered within a specific time frame, Lordship. The representations are at page 28, Lordship. There is a representation.
How many representations have you made?
Lordship, all tell one representation, a hard copy was furnished, and subsequently 3 emails were there. On 9/4/2024, there was the representation to the director of this regional IGNO office, Lordship, and subsequently in the official email, it was on 12/4/2020.
Anyway, that's a different thing. The hard copy is page 28, correct?
Lordship,
Yes, anybody? Uh, no, nobody, no standing counsel. Revenue, elementary. You can,
Lordship, because I had preferred an RTI application wherein they have also given a reply, that is at page 27, Lordship. They say that they did not issue any non-criminal certificate at that point of time, Lordship. Page 27, Lordship.
My lord, this
Yes.
certificate was issued by the, my lord, that communication was issued by the Assistant Commissioner. So why the revenue?
The circle officer, Lakhimpur Revenue Circle confirmed it, Lordship.
Output officer is falls under the Deputy Commissioner. Okay.
heard Mr. M.P. Sharma, learned counsel for the petition. Stop. Also heard Mr. J. Hendrik
For respond number
learned standing counsel,
revenue.
Revenue Department for respond number
Two, Lordship.
two, Deputy MS. MS MD Barman. Then DD Barman, then that additional senior government. It appears for 3 and 5, and MS N Fuka, then that standing council elementary division appears for the respondent number 4. Stop. Para. You are serving as
Principal of the Emmanuel English High School, which is situated at Pailapur in Kachar district.
the petitioner is presently serving as the principal of the Emmanuel English School.
English High School,
English High School.
yes, Lordship. PAILAPOOL. That
Where's that?
that is at page 11, Lordship. Paragraph 18, the name is there, Lordship. Otherwise also I can show.
Is presently serving as principal of Emmanuel English High School. Pailapur, correct?
Lordship,
Pailapur. In the district of,
Kachar.
in the district of Kachar. Stop. The respond number 6 is the daughter of
Lordship.
the petitioner. And she was also serving as assistant teacher of the Emmanuel English High School. Pailapur. Stop. Para. The petitioner is aggrieved by the fact that the respond number 6, who is her daughter, had resorted to falsehood to secure admission into the B.Ed course under the
Indira Gandhi.
Indira Gandhi National Open University. Comma. In the year 2012 by misrepresenting that the respond number 6 belongs to the non-creamy layer of utter backward classes within bracket OBC community. Stop. It is the case of the petition that the Department of Personal Training within bracket DOPT Government of India by office memorandum dated 14/10/2008.
Page 20.
Issued by the director. No, then
Was issued by the director only.
Ministry of Personnel,
Lordship.
Public Grievances and Pensions. Department of Personnel and Training, Government of India. Has laid down that the son within bracket S and daughter within bracket S of persons belonging to other backward classes and having gross annual income of rupees 4.5 lakh or above, or possessing wealth. No, or above, shall fall within the category of criminal. Stop. The further case of the petition is that the gross annual income of the petitioner for the year 2010-11 and 2011-12 is above the set limit, and therefore her daughter respond number 6 will not be entitled to the relaxation granted to OBC community, and therefore the OBC within bracket NCL certificate which was submitted by the respondent number 6 for securing admission into the B.Ed course conducted by the Indira Gandhi National Open University is effective. It is also the case of the petition that in view of the fact document submitted by the respondent number 6 to secure her B.Ed course in the Indira Gandhi National Open University, the same has an impact on the
Reputation of the
petitioner, has an impact on the reputation of the petitioner
as well
as well as the petitioner's school. Para. The petitioner therefore made a representation before the regional director, Indira Gandhi Open University, Guwahati, Assam, on 9/4/2024. 2024, disclosing the aforementioned facts and to take appropriate steps against her daughter, respondent. Stop. The grievance of the petitioner is that the representation filed by the petitioner on 9/4/2024 is yet to be considered by the regional director, IGNO, respond number 1. After hearing the learned counsel of the parties, the dispute petition is directing the respond number 1 to consider the representation made by the petitioner on 9/4/2024 and dispose of the same by a speaking order and in accordance with law within a period of 1 month, no, 2 months, within a period of 2 months from the date of receipt of a copy of the order of this with the officer of the receipt and direction of this petition.
Lordship will also record that I have preferred emails on 12/4/2024, 19/4/2024, and 7/5/2020.
On top, plus the petitioner had also sent her representation through email on
On 12/4/2024,
12/4/2024,
19/4/2024,
19/4
and 7/5/2024.
and 7/5. However, no steps has to be taken.
Obliged, Lordship.
Then.
My pleasure, Lordship. My lord, one advertisement was issued
Hmm.
on 7/8/2019 for appointment, selection and appointment to the post of Assistant Professor Bengali in the GC College and others.
Hmm.
Advertisement is page 24. Petitioner, page 24.
Yes.
Serial number 5 of the Assistant Professor Bengali.
Hmm.
It is against the roster number 91 and reserved for OBC. Petitioner is a OBC candidate and she is a doctorate in Bengali. So she
This advertisement is dated
6, my lord, the dated, it is dated 7/8/2019.
where can I find it?
My lord, that left, my lord, in Bengali, it has been legal 7 August 2019.
Where left?
Paper. The paper is at
Top left in
top left,
in Bengali lot.
left corner top.
I can't see. Okay, 7.
8/2019.
Then?
My lord, she participated in the selection interview. Interview was held on 17/11/2022. She was invited to appear, which is at page 25 by a letter dated 2/11/2022.
Page?
Page 25.
Hmm.
She was invited to appear in the interview on 17/11/2022 Thursday. Accordingly, she appeared.
Yes.
Then, my lord, page 26, a list was forwarded by the Director Higher Education Assam on 35/2023 at page 26.
Hmm.
List of pending appointment of Assistant Professor Librarian, page 27. And at page, my lord, 28, at serial number 11, name of the petitioner appears, page 28.
Yes.
And Assistant Professor Bengali. Then in right column, one notice there, complaint received, endorsement of Honorable Minister Education Assam to inquiry. That is a against all the candidates, serial different candidates, some notes are there. Some that 12G resolution of permanent release of not submitted. Then, my lord, at page 27, serial number 10, another post of Santan Guamujumdar Amrita Dotto, Assistant Professor Commerce of GC College. Clarification of roster point and submission of separate proposal. By this time, those persons have been appointed. But with regard to the petitioner, her appointment was kept pending long. She submitted representations. Now, on my lord, 10th of June 2024 at page 37, the principal GC College forwarded 2 letters of the Director of Higher Education to the petitioner. At page 38, I have imprinted this.
Yes.
This is the letter of the Director of Higher Education addressed to the principal. Re-advertisement of the post of Assistant Professor in the Department of Bengali OBC MOBC category roster point 91. In inviting reference to the subject stated, I would like to inform you that you may re-advertise the post of Assistant Professor in Department of Bengali category poster as per latest government OM. The advertisement should be published at least 2 leading newspapers across the state and also in college website for wide publicity.
Then, my lord, at page 39, another letter has been addressed to the principal by the Deputy Director Higher Education Assam regarding appointment of the post of assistant professor in the Department of Bengali in GC College, Kachar. In inviting a reference to this subject cited above, I am directed to inform you that this directorate already accorded permission to advertise the post of assistant professor in the Department of Bengali, OBC, MOBC, roster 91. Your college, due to single candidate, reason given that due to single candidate appeared in the interview by the office letter number so-and-so dated 27/12/2023, you are therefore requested to inform the same to the incumbent accordingly. Thereafter, the principal forwarded me the letter 27/12/2020 and this letter, which is 35/2024. So my humble submission before your lordship, whether a single candidate I appeared in the selection and appointment, it cannot be a reason that the re-advertisement is given. And by this time, my lord, I have crossed the age to participate in the selection process. Now I am 43 years. At the time of advertisement, I participated. So my humble submission is totally arbitrary. I cannot be held responsible.
Notice may go at this. I'll obtain section 5. Interim lordship, selection, getting selection doesn't give the indivisible right. So we'll have to see what's the reason why. Because
Then you
some
don't,
complaint was also there.
you don't advertise for the time being.
Yes, for the time.
That is the college
But
authority.
Mr.
Yes,
Is
sir.
not London Council for the petitioner issue notice. Mr.
A.R. Kohbilder.
A.R. Tabildar, London Standing Council, Higher Education appears for respondents.
1, 2, and 3.
1, 2, and 3. Stop. Extra copies of it. Please. Petitioner to take steps for service of notice on respondent number 4 by registered post AD within 1 week from today. Respondents are allowed to file counter affidavits. List the matter of court. In the interim, the communication, don't say communication, the letter
Page 38 and 39.
dated 27/12/2023, written by the Director of Higher Education, Assam, and addressed to the principal, GC College, Silchar, Kachar, as well as the letter dated 35/2024, written by the Deputy Director of Higher Education, Assam, and addressed to the principal,
GC College, Silchar, Kachar.
Guru Charan College, Silchar, shall remain suspended till the next suit.
Obliged. Deeply obliged.
He's
Is a writ of quo warranto.
Warrantor, yes, we are seeking a writ of warrantor. If I may take your lordship directly to the qualifications prescribed under the NCT. I'm relying page, lordship 25. Sorry,
Yes.
page 42, lordship. This is part of a honorable court's order wherein
Yes.
the writ petition was filed by the said respondent number 3 itself. Lordship, page 42, paragraph 8. The NCT regulation prescribing the qualifications is quoted herein. The clause 5.2, faculty shall possess the following qualification principle: postgraduate degree in arts, science, humanity, commerce with minimum 55% marks, and MA with minimum 55% marks, and thereafter PhD in education, 8 years. We are concerned with lordship 1A, 1 and 2. The petitioner does not, the respondent number 3 does not possess 55% marks, and also the MA degree, which she has subsequently acquired, is under cloud, as is reflected from this order itself. I'll place parts, this was a this was an order passed in a writ petition
filed by the said respondent number 3, wherein she had questioned the appointment of another lecturer as in charge principal. The Honorable Court, in fact, directed an inquiry, did not allow her prayer for her appointment and with the observation that her qualification is under cloud. I'll refer to that.
This writ petition is filed by the respondent number 3.
No.
The one you are referring to, page 42.
Yes, yes. By the respondent number 3 in the year 2019, she had claimed the post of IC principal when the authorities had appointed some other lecturer of that college, senior lecturer of that college had appointed her, and she had questioned her appointment, seeking that she is qualified. The Honorable Court did not allow her writ petition, in fact, directed a inquiry because the qualifications of the petitioner therein, that is the present respondent number 3, is under cloud because it is prima facie clear, I'll place from the records, that she does not have that 55% marks norms in her postgraduate qualification in her MA degree. And secondly, the MA degree which she subsequently acquired, she obtained that without obtaining the necessary permission which is required of government servants under Rule 13 of the Conduct Service Rules. That is why there is a clear observation by the Honorable Court that the qualifications of the petitioner therein is under cloud, and has just directed an inquiry. I'll place that observations also from that order itself at page 43, Lordship. Next page of that. Page 43, paragraph 11. Herein, it has been in the present case, it has been contended by the petitioner. Petitioner means the present respondent number 3, that the respondent number 8 does not possess MA degree, and as such, respondent number 8 is not qualified to hold the post of principal even on in-charge basis. On the other hand, though the respondent number 8 does not dispute the aforesaid position, she, however, contends that though the petitioner possesses postgraduate degree at required percentage of marks, her degree is under cloud and cannot be considered as valid since she had obtained the postgraduate degree without obtaining permission from the concerned authorities, which is in violation of Rule 13 of the Conduct Rules, and an inquiry is still going on in this regard. It is to be noted, it has been admitted by the respondent number 8. We can skip over. Next, paragraph 13, the directions of the Honorable Court there. Be that as it may be, from the claims and counterclaims of the petitioner and respondent number 8 as regards fulfillment of the eligibility criteria to hold the post of IC principal, this court is of the opinion that the issue requires re-examination by the authorities by taking into consideration the following aspects. If there have been any eligible candidates, lecturers, also in a nutshell, the direction was that if there are any other eligible candidates, the authorities should consider their claims and appoint them instead of appointing the petitioner therein, that is the present respondent number 3, and the other other respondent, private respondent, who was at that point of time holding the charge of principal. If there are other eligible candidates, they should be appointed for holding the post on the basis of seniority. That was the direction given. Thereafter, an inquiry was held. If your Lordship peruses the next page at 45, the inquiry, minutes of the inquiry which was held, page 45.
Yes.
But yes, the second paragraph onwards, but Srimati Tulumani Devi is the senior most lecturer of government section, that is the private respondent in that writ petition, who was holding the charge at that point of time. According to merit position shown by APSC and date of regularization of service order. In the APSC advertisement of 1994, the minimum qualification for lecturer was 55%. In the postgraduate degree with BT BEd, Srimati so-and-so had 56.67% in her MSc and BEd. But Srimati Bordoloi had 53% in MA with BEd. That is the present respondent number 3 and the petitioner therein. After perusing the entire education documents of the respondent number 3, the departmental authorities had opined that whereas the advertisement itself claimed as per the rules that 55% is required, she had only 53, and with BEd. they had not even referred to the MA degree, which was subsequently acquired by her, and which is an essential prerequisite for being appointed as a principal in a B.Ed college, as I had shown placed the NCT regulations before your lordship. Thereafter, but after the retirement of the then IC principal, these respondent number 3 was allowed to hold the charge of IC principal, and that is at page 25, lordship, by order dated 16/2/2023. Even though she does not have the requisite qualification, 25. Thereafter, this present petitioner, he filed several representation showing out the ventilating the grievances. At page 1 is at page 26, 27/12/2023, the first representation. 27/12/2023. The entire grievances he raised out regarding non-possession of our requisite qualification by the respondent number 3. I won't be repeating what is the contents, because the same what I have submitted is there. And the second one at page 29, 29/5/2024. 29/5/2020. Thereafter, after these representations were filed, when the authorities took some steps, the government directed the Directorate of Secondary Education to Director of SCRT to find out whether the present respondent number 3 has obtained the required NOC from the government for pursuing her MA degree course as is required. If your lordship peruses page 56, page 55. This is a letter from the Additional Director to the Government of Assam Elementary Education Department to the Director, SCRT Assam. Because B.Ed colleges come under the SCRT. With reference to the subject cited above, I'm directed to inform you that so-and-so lecturer.
This is in 2019.
Yes, lordship. They were carrying out these steps. Yes, 2019, it goes on. Yes. They directed the respondent number 2 to furnish the copy of the NOC, whether she has got the obtained the NOC. The reply, which was finally furnished by the said respondent number 3 at page 57. She had explained that she had pursued her MA course under the National Institute of Teacher Education in the year 2005-2006 at Khetri near Jagirod. And she had pursued the course after her college house. That is her explanation. And at that point of time, she came from Nagaon to pursue her course. That is the explanation there. But she did not submit the NOC, meaning thereby she does not have the NOC. Her statement is that 2005-06, the institute from which she had pursued her MA course was at Khetri Jagirod, and she pursued her. But the petitioners, they filed an RTI application before the institute from which the respondent number 3 claims to have obtained her MA degree. And they say they have issued a certificate at page 59, wherein they say at that point of time where when the respondent number 3 claims to have pursued her course there, the institute was not even located at that point at Khetri Jagirod. It was in Guwahati itself. At page 59, they say, certified that the type copy of the certificate which that. Oh, this is the certificate of MA degree. I'm sorry, lordship, page 61. Page 61. The institute had certified that so-and-so had admitted into the MA course in the session 2005-06 and passed MA in 2007, bearing roll number 50. Her admission form was submitted to the Department of Education, Guwahati University, as per instruction. In the year 2005-06, the institution was situated at Ganeshguri, Guwahati, and shifted to Barbary VIP Road in 2015 and finally shifted to Khetri in May 2019. She claims to have pursued her studies in 2005-6 at Khetri, Ahmed. But the institute themselves, pursuant to an RTA application, they say at that point of time it was in Guwahati, at Ganeshguri. And it was shifted to Khetri only in the year 2019. So like what is prima facie clear from the records and from the documents of from the inquiry also conducted by the department, as well as the Honorable Court's observation that the petitioner, the respondent number 3 does not possess the essential qualification. What is required to be for being appointed as a principal of a B.Ed college. So what, so the appointment of her the respondent number 3 as even IC principal is not sustainable. And moreover, they are now, what we have come to know, she's trying to be, she's seeking a claim for the post of regular principal also. But in the meantime, also after filing of this petition, what we have come to know, the department has directed an inquiry also against her. So this document yesterday also only we have come across. And at this point of time, I'm not seeking a stay of our continuance or anything. We just want that a proper inquiry should be held into the educational qualifications of the said respondent number 3, because what is concerned here, she is just holding a public post. And it is clear from the records that she does not have the qualification as prescribed by the statute. Lordship may kindly peruse this. Only that much, Lordship. Let them hold an inquiry, and after that, if everything is clear, that's it. Because they've already.
They're already holding an
Yes,
inquiry.
yes. That is what is
They can
reflected
continue
in that
the
letter.
inquiry.
What is reflected in this letter? After completion of that inquiry, they should consider her appointment, if at all.
Yes, Bharat.
What? This is not an ordinary petition, which is co-warranty. Person who is seeking a co-warranty must have the local standing to pursue this case. Apart from all the facts, now the new inquiry has started, and what on that, whether this person is entitled to pursue the case. Lordship will turn to page number 9, very first paragraph. In the middle, he says the petitioner is a retired principal of diet. Paragraph number 1 in the middle, the petitioner is the retired principal of diet, Morigaon, and presently is holding the post of Vice President, Alumni Association of the Government, Shiksha Mahavidyalaya, Nagaon. This is the school man. He is the Vice President of the Alumni Association of the particular school man. He has an interest. He should not have any interest in while pursuing their co-warranty role. He has an interest. And there are decisions of the apex court and the high court manner. The person who is interested should not pursue the co-warranty. I will hand over a decision
He's
of
an
the
ex-student. He's an ex-student of that college. And
Now he's a
alumni association, that means
decision of this apex, this and high court on based on the apex, this or based on the apex court.
only says for issuance of a writ of quo, one must be a citizen, and as the posting for which the question has arisen
Paragraph 27, my lord.
must be a
What-
public post, and the person concerned should not, if does not possess the qualification as prescribed by the statute. That is the only
Person who has the interest
criteria.
of the interest should not file a co-warranty.
Public interest. Yes, public interest. One cannot have a public interest. In public interest.
On merit, I don't have to say anything, my lord. That other inquiry and everything.
Yeah, what he is saying is that he is an ex-student.
Yes.
Well, so now he is holding the what is he holding the post? Vice President of the
Alumni
Alumni
Association.
Association
So what is
Students.
wrong?
of the particular school.
What is wrong?
School, my lord.
So what?
He is an he's an
Who is she
interest.
notice?
Not-
But MSD Board
Borough.
Land Council. Issue notice. Elementary. MSN Fukan Standing Council Elementary Education appears for the respondents.
I appear for responsibility.
1. And Mr. S. Boral in the Standing Council,
SCRT.
SCRT appears for the respondent.
True.
petitioner to take steps for service of practice under respond number 3 by registered post AD within 1 week. Respondents are not required their affidavit. Please start your form.
Lordship, as it is an, communication reflects that inquiry has already been directed. Let them complete the inquiry,
Why
Lordship.
should I interfere now? Why, that was written on the 1st of June. Why should this court interfere at this stage?
Lordship, with, kind of an observation,
Let them
Lordship.
let them come up with the affidavit, then we'll see what happens.
Lordship, that
There's no
observation is.
point of interfering in all.
Understand,
in all
Lordship.
communications.
Lordship, because earlier also, the whatever inquiry, what they had directed, they had directed her to furnish the NOC. Nothing came about. Now this appears that inquiry has
Now
been
they've started the inquiry. Communication was on the 1st of June, correct?
Lordship, that observation may be as it the regarding the these communication.
Let's see what happens. Let's see what you're totally submitting on apprehensions. On apprehension, this court does not pass any order.
No, Lordship, apprehension, not on the Lordship, I'm not on the regular, not the continuance of far as I see, we are challenging our
That's fine.
appointment also as
That's
IT
how-
principal.
that's why we should
Because
not
both
take-
are interrelated. Unless and until one has a requisite qualification for holding the regular post,
That's
one
why we
cannot
issued
claim.
notice. That's why issue notice. Notice has been issued. Let them see, we'll see. If further on they stop with the inquiry, then we can interfere. But at this stage, let them continue with the inquiry, we'll see what happens.
Lordship.
Well,
Yes.
before I take your lordship to the infant seniority list, lordship, I beg to take your lordship to the page 17, the initial appointment of the petitioner.
Page 17,
Page 17, lordship.
as in a stipend.
Lordship.
Hmm.
17, this is the initial appointment in the Marwari Hindi school, primary school, lordship. It was on 10/6/1992.
Rajesh Kumar Tripathi.
Tripathi.
Hmm.
Thereafter, lordship, I completed the junior basic training on 1/6/2000, lordship.
Page,
Page 18, next page.
yes.
18, I completed the junior basic training on 1/6/2000, lordship. This is the certificate issued by the principal, lordship.
Then,
Page 19, after the junior basic training was, after completion of the junior basic training, the follow, lordship will find at page 19, the following LP school teachers are hereby confirmed their services with effect from the date of issue of these orders, as the teachers are rendering continuous service without this is tactical mistake, lordship, without adverse remark during the period of their service. My name appears at serial number 6, lordship.
yes.
Now, if I take your lordship to page 23,
You're confirmed with effect from
effect from lordship, 2011 January 2002. Next page, at page 20, this is the date. 11 January 2020 or 2002, sorry.
yes.
Now, if I take your lordship to page 23, this is the detailed status of the school under the DE Assam.
23.
23. Serial number 2 is my name, Rajesh Kumar Tripathi.
Serial number 23.
2. Serial number 2 at page 23.
Yes.
Lordship. Now, if I take your lordship to the impugn seniority list at page 24. Here, I have been attached to the this what is called Durga Mandir Hindi LP School, in the district of Dibrugarh. My name lordship will find at serial number 4 on attachment. And my seniority has been placed at serial number 4. Whereas at page 23, my seniority was at 2, serial number 2.
Yes.
Now, if I take your lordship to paragraph 8 of my petition, lordship, I've quoted the rule At page 10, Lordship, 10 and 11. Lordship, got it. That the petitioner beg to submit that Rule 11 of the Assam Elementary and Secondary Teachers Regulation of Posting and Transfer Act 2020 provides that transfer of a teacher shall not in any way affect his original seniority in the respective cadre of the service. Earlier, Rule 3, Roman 3 of the Assam Elementary Education Professionalization Service and Conduct Rule 1981 provides that inter-se seniority of the teacher belonging to the cadre class grade shall be determined as per existing government rule. So my seniority should be there, Lordship, because I was placed on attachment, not on my own request at page 24. This is the impugned seniority list. So that Akhilesh Kumar Singh is going to retire on 30th June, Lordship, this month. And I, being the second senior most, I will hold the in-charge principal till the regular principal is appointed, Lordship. So to deprive me this impugned seniority list has been prepared, placing me at serial number 4. And this private response number 2 and 3 were
Let us
upgraded,
see that,
Lordship. Which I have also stated in paragraph 10 also. Lordship.
yes,
Para 10, Lordship, that the petitioner submits that the seniority list of the teacher of Sri Durga Mandir LP School was prepared by the then headmaster as on 31/10/2020, wherein the name of the petitioner appeared as serial number 4, just below the present headmaster of the school and above private respondents. Again, a seniority list of teacher of the school has been prepared by the present headmaster on 10/5/23, wherein the name of the petitioner appeared as serial number 2 after the headmaster Sri Suresh Singh, who is going to retire on 36/24 on attaining the age of superannuation. So, Lordship, if this impugned seniority list is prepared by the headmaster in a colorable exercise of power to deprive me, Lordship, from getting the post of in-charge principal, Lordship, and to facilitate that private respondent number. Private respondent number 6, 7, and 8, Lordship. So my prayer before your Lordship is, in the interim, your Lordship may be pleased to stay the operation of the MP seniority list. And direction may be made that after 30 June 2024, I may be allowed to hold the post of in-charge principal.
that will be giving all your prayers in the writ petition. That will be among the disposal of the writ petition.
This is my prayer, Lordship, the interim prayer. But Lordship, if your Lordship stays the operation of the MP seniority list, that will be also the Lordship.
Yes, okay.
Your Lordship will kindly find page 22. Page 22 is not a seniority list, but it's a school-wise database of these teachers.
What is this, page 22?
Page 22, where
School-wise
where
database.
it has been projected that his name was earlier in serial number 4, the petitioner's name. But page 22 is not a seniority list, my lord. It's a school-wise database of the teachers. Page 23 is also the same. Now, my lord, your Lordship will find para 3 of the repetition, my lord. Page 8.
Page 23 is not the same.
My lord, page 23 is the details of the status of the school under the DE.
But my
It's the details of the teachers who are working in that school, my lord. Now, if your Lordship finds page 8, para 3 of the repetition. Petitioner is working in that school, my lord, on being attached, only on being attached. He is not being transferred. And therefore, my lord, this order has not been annexed. Because usually, my lord, attachment is always for a temporary purpose attached to discharge his duties from that school. He is not transferred. So therefore, my lord, the Act of 2022 would not be applicable.
no, my lord,
In fact, my lord, the seniority list, my lord will see the page 24, the type copy of the seniority list. He has been shown as a teacher on attachment.
Yes.
So he's not regularly posted there.
This attachment usually is done for a temporary period, whereas in order to maintain the PTR, if there is a requirement of a teacher.
Then my
No,
seniority will go,
let
Lordship.
them produce this transfer order, my lord. That will clarify, my lord, everything.
No, transfer order has not been given.
No,
No.
para 3, my
This,
lord.
this page 24, serial number 4 on attachment. It is clearly written on attachment. No transfer order was issued to me, Lordship. I was attached.
Any attachment order was issued?
No.
My lord, will kindly see
That-
para 3
that-
of the petition.
Yes. On attachment, yes.
Begs to state that he was transferred to so and so on attachment in the same capacity and
Yes.
he joined in the so and so. There has to be an order, my lord. Without an order,
No order has been passed, Lordship.
Are you sure?
Yes, Lordship. I'm sure.
2008, my lord.
2008, no order was issued.
Since 2008, you are serving there.
Yes, Lordship.
Without there being any order, my lord, how can there be an
Then
attachment or transfer also?
let that, if there is any order, let my lawyers produce. But so far I am concerned, Lordship, my instruction is concerned, no order was passed, Lordship.
Yes,
in
not even
2008.
annexed the joining report, my lord, that might have indicated the order date.
This, the one it's saying number one, he's retiring on,
He will be retiring on, Lordship, on 30th of June, Lordship, this month.
he is the principal
He is the in charge
He
principal
is the in charge.
of which school?
of this Durga,
This
Sri Durga Mandir Hindi LP school.
And his initial appointment was in Marwari Hindi primary school.
Yes. Yes, that I have
So
seen.
how he came to Durga, my lord, there has to be some order. And para
I
3 will
on
clearly
my
indicate-
own has not come. This is the authority who has attached me in the Durga Mandir LP school.
By which order?
There was no order, Lordship. From Marwari Hindi LP school, Lordship, primary school, I was placed on attachment in the year 2008, Lordship. So far, my instruction is concerned, no order was issued, but I was attached.
How did you go on attachment then?
That is the authority who has attached me, Lordship.
There should be some documents.
It has to be, my lord. It cannot be on a verbal instruction because he's drawing his salary.
Yes.
How the treasury will release the salary if there is no order?
Now, if your
From the
Lordship
school.
comes to page 23, this is the Sri Durga Mandir LP, Hindi LP school. The Rajesh Kumar Tripathi.
My lord will issue notice, my lord.
That column number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, Lordship. Date of joining in the present school. Is written.
That's fine, that's fine,
Yes.
that's fine. You
There's no
joined-
dispute to that.
Yes.
On what basis did you join this
That
school?
is what, Lordship.
You don't know it, sir. You don't know.
No, I have not been served with any order, Lordship. This is my instruction, Lordship.
Then on whose authority did you go and join this school?
That is, Lordship.
नहीं नहीं अपना order क्यों था? Because this seniority list shows there are 2 teachers who have come on attachment.
Yes.
Serial number 4 and serial number 7.
Yes. And this serial number 7 was attached on 1/2/2023.
If he would have been transferred, well, it would have indicated on transfer, not on attachment.
There is one issue that is intriguing this court.
Yes, yes.
On what basis did you go on attachment? How? How?
That I cannot submit before your Lordship at this stage, Lordship.
Unless you satisfy this court, then what type of interim can this court pass? You take some instructions, we'll take up on Friday.
Lordship.
On request made by Mr. Ardar and counsel for the petition.
Is the matter again on 28th June to enable him to receive instructions.
Development.
In the meantime, Kaushik, you can.
I'll also.
Yes, let him on.
Usually all attachment are done in that manner. my lord. It is a temporary attachment when there is no teacher in that school and there is a requirement of to maintain the PTR. He draws his salary from his parents' school, but he discharges his duty in this school.
That also I will take instruction.
13.
Lordship,
What is this?
the petitioners are challenging the promotion of the respondents number 9 to 15 and at the same time also praying for their promotion. But what has happened in this case, my lord, as per the regulation which govern the service conditions of the petitioners and the respondents, both are equally situated, my lord. They are identically situated in the sense that as lecturers in the homeopathic colleges of Assam, the petitioners have their degree in homeopathy plus the required period of experience in the post of lecturer 10 years or more than 10 years they have. On the other hand, the respondents, my lord, they have PG degree, postgraduate degree, and the required experience of 4 years. So by virtue of that qualification and experience, both these streams qualify to be promoted to the next higher grade of reader. Now, what has happened in this case, my lord, ignoring the petitioners, my lord, which are degree holders in my lord, homeopathy with more than 10 years experience that qualified them for the promotion, they have promoted only the respondents number 9 to 15. That is the grievance of the petitioners. Huh? Yeah. And there is another issue. They also haven't the finalized gradation list that has been prepared. Now they also haven't followed that. The respondent authority. Now there is third issue in the sense that they have promoted them, and now by virtue of their promotion, which took place on 25th of January, 2023. Since then, we have been representing, we are taking up the issues with the respondent, but nothing has happened. Now, they, in the promoted post of reader, if they acquire 2 years experience, they will further qualify them to be promoted to the post of professor, lecturer, the reader, then professor, So that will make the issue further complicated. So therefore, I pray that, the notice be issued at this stage, that no further, and only a direction should go that no further promotion be given to the respondents. That much, to the private respondents.
No, when are they were promoted in the year?
We have not promoted. They were promoted on 5th of January 2023.
Maintainability also an issue, my lord. More than 1.5 years back, my lord. They have been.
23.
No, issue they are taking up. It is not a fact, my lord, that even they have started a fresh proposal, your lordship, for our proposal, but nothing has happened, my lord. At Annexure 23, page 119, my lord. But before that, my lord, the promotion orders and the, my lord, let me just place it. Annexures, my lord, 13 and 14, my lord. Page 96. That is the minutes of the DPC, my lord. What had happened, my lord? The competent authority sought for clarification whether to promote the postgraduate or all of them, my lord, including the petitioners. He had written for clarification. He didn't wait till the reply reached him, my lord. Before that, he held it. That is the malafide. But anyway, I am not making anyone in person, my lord, any respondent in person. So therefore, but that is the issue. Your lordship, the documents will show that he could have waited and he could have, because in the reply, the superior authority or the apex council of homeopathy in the country, my lord, they clarified that nothing doing. The people have to be promoted only on the basis of the provisions in the regulations that was relevant at the time of their appointment. As per that, my lord, it is degree with 10 years or postgraduate with 4 years. And if they had, my lord, followed the gradation list, my lord, which has been finalized, nothing would have happened, my lord. In the result, what has happened, my lord? Junior persons have been promoted, my lord. We are senior persons,
Okay.
my lord. That is the DPC, my lord, annexure 13 page 96.
You post service of notice on the private respondents, and then after that, we'll consider entry.
No, only, my lord, that
Yes, my lord.
further promotion may not take place, my
No,
lord.
that there's still time. If they don't appear on the next date, then we'll consider. that.
Yes, my next date will be, your lordship will kindly give it for consideration interim order.
PD Goswami, then we consider. Issue notice. Union,
One and two.
MS,
And then Sharma.
and then Sharma, you're the CGC.
Yes, sir.
You're the CGC. Appears for the respond number one. One and two.
You are appearing behalf of G program.
You're not the CGC.
Yes, Lordship CGC, but I'm appearing behalf of my senior.
Doesn't matter, you're the CGC. Appears for the respondent one and two. Mr. B.B. Bora,
I am appearing for the respond number 3, 4, 5, and 6, my
then
lord.
the standing council, Health Department.
Yes, my lord.
Appears for
3, 4, 5, and 6.
3, 4, 5, and 6. 6 also?
Yes, my lord. 3, 4, 5, and 6.
Are you sure?
Yes, my lord.
Principal in charge.
Yes, my lord.
Then how about 7 and 8?
7 and 8, my lord, those two homeopathic colleges have already been merged with the 6th college. my
Their officers survive, my lord. Otherwise, my lord, the college has become one.
Okay. Petitioner to take steps for service of notice on the respondents 7 to
7 to 15, my lord.
15 by registered post within 1 week from today. Please the matter of the 4 weeks. The prayer for entry shall be considered on the next written notice.
My lord. Your lordship has fixed the date, my lord.
I'm not fixing.
A
Let
date,
it come up.
yes.
Supplementary list.
No, interim order shall be considered. My lord, may I just pray, my lord, interim order in respect of promotion to the next promotion?
Prayer for entry will be.
Or your lordship may, my lord, further promotion, my lord, on further promotion. That much, my lord. Interim order for consideration.
Interim is sufficient. For further promotion, not required. Yes.
Step to lead, Lord, my lord.
Please, your lordship. Petitioner lordship, he is serving as a in-charge principal in Krishna High Secondary School, lordship, Gwalpara. Lordship, what happened in this case, lordship? One Robiul Haq, lordship, his name was recommended for the post of SMDC president. And lordship, on that occasion, lordship, one Mehboob Ali filed a writ petition, and his recommendation has been suspended by this honorable court in WBC 279 of 2003. Now he thinks that I have instigated the petitioner to file his writ petition, and that is how lordship he filed complaints against me. And his allegation is basically, lordship, I have collected exorbitant fees from the students. Secondly, lordship, he has also questioned my educational qualification. And thirdly, lordship, he has stated that I have announced the results of class 9 on 2 occasions. And that has been enquired by the ADC, lordship. Gwalpara, lordship, will kindly find at page 42. Page 44, lordship, it is a forwarding letter, page 44, may kindly read it. It's a type copy also. A news item was published in the News Daily, Dainik Agrawal. There are 3/11/2023 with the caption Krishna Ussata Madhyamik Vidyalaya, Orajakota. The allegation in the news item are as follows. Mismanagement of MDM that is serving of half an egg to the children instead of 1 egg once a week on every Wednesday. Declaration of 2 numbers of result sheets of class 10 pre-board examination. One Anwar Hussain has submitted a petition alleging misbehavior of Zakir Hussain. Lordship, may kindly skip, then findings, lordship. It was learned that students other than class 6 to 8 were also having MDM in the school, due to which the cooks were serving only half an egg instead of 1 egg to the children in the school. The cook stated that as they could not identify
and distinguish between the students from class 6 to 8 standards and the students from class 9 to 10 standard were also served MDM in the meal. To make available the eggs to all the cook used to twice the eggs into two parts and serve to all the students. So this was practiced intentionally since a long time back. All the teachers and cooks were instructed to discontinue this practice. They were instructed to provide MDM and one full egg to the students of class 6 to 8 only as per rule. Corrective measures have been taken by the institution as instructed in this regard. Then the fees in different categories like registration, examination fees, etc. were charged as per government guidelines. The fees were collected by the assistants and receipts were also issued. The in-charge principal, Krishna ISS School, declared the results of the class 10 pre-board exams 2 times on 25/10/2023. One of the result sheets contained roll numbers of the duly passed students, simple pass students, and withheld students. The results of some of the students' results were withheld due to non-payment of fees and absence in the examination. However, the reason of withheld roll number was not mentioned in the result sheet, which raised confusion amongst the students. The students protested and had an altercation with the school authorities, and the students spread the rumor that the IC principal indulged in unfair means of changing of marks in the exam. However, the affairs of the pre-board examination were looked after by an examination board consisting of some teachers and officer assistants. The entire process of tabulation and preparation of exam results was conducted by this board. The IC principal did not indulge or interfere in their work. Later on, the students were appeared when they were informed that all will be allowed to register for the HSLC exam, irrespective of the outcome of the pre-board exam result. Rafiqul Haq, Yaqub Ali, and Gyanendra Koilta were the board members of the pre-board examination. Their statements were recorded, wherein they have stated that Zakir Hussain, IC principal, Krishna ISS School, was not directly involved in preparing the result of the pre-board examination. Regarding misbehavior of Zakir Hussain against Anwar Hussain, it is learned that during school hours, Anwar Hussain entered the school premises and sought for information from Zakir Hussain. Zakir Hussain refused to provide him any information and they had an altercation. Anwar Hussain was informed to follow norms of the journalistic conduct. He was also informed to take help of RTI Act 2005 for seeking information. On further inquiry, it was seen that 20 numbers of Pakka rooms were seen to be constructed illegally on the land of Krishna ISS School boundary. As per complaint submitted to the Inspector of Schools, GDC, Gwalpara by Anima Begum and 12 others dated 19/9/2022, it is alleged that one Fazil Haq, a teacher of Krishna ISS School, has collected various amounts ranging from 18,000 to 50,000 from each of them in the name of construction of shops in the land of the school. It is seen that 20 rooms are half constructed on the land of the school illegally by Fazil Haq. Fazil Haq is also functioning as the secretary, Habraghat Darul Ulam Madrasa. In this respect, Noor Hussain, the ex-president SMC Krishna ISS School, along with 65 others, have complained against Fazil Haq, alleging his involvement in various activities. Also, guardians of students of Krishna ISS School, that is Ariel Haq and 4 others, have submitted statement in favor of Zakir Hussain, IC principal, SS School, that during his tenure, the school is running properly and discipline is maintained in the school. It is recommended that steps may be taken to evict and demolish the illegal construction, and with the land of the school, disciplinary action against Fazil Haq, assistant teacher, may be taken due to his involvement in illegal collection of money and construction of rooms for shop with the school within the school boundary, and also for performing as secretary, Habraghat Darul Ulam Madrasa. The entire dispute has come about due to Fazil Haq's involvement in illegal activity and opposition of this by Zakir Hussain, IC principal, Krishna ISS School. Fazil Haq is involved in instigating the teachers, the local public, and also spreading rumors against the school. Now, Lordship, by this inquiry report, the entire allegation with regard to construction that has been done during the earlier tenure by one Fazil Haq, and he was also placed under suspension. And then I was instrumental in demolishing the house by taking the help of circle officer and Lordship the ADC. And Lordship the school SMDC is now being functioned by a government officer. One Rishiras Das, he is the assistant commissioner. So there is no any scope for any misconduct, Lordship, or any malpractice by anyone. Now, Lordship, basing on this inquiry report, there is one more inquiry by the Inspector of Schools. Your Lordship will find at page 60 to 61. Even Lordship, DC has also given a clarification, Lordship, at page 56. Page 56 may kindly visit.
Yes.
The The illegal construction of shops, houses, lands, etc. in the premises of Krishna Higher Secondary School has been the subject of discussion in the media, social media for the past few days. After a publication of this newspaper report on 3/10/2023, the Gwalpara District Administration appointed an additional district commissioner to investigate the matter, and the investigation officer, together with the inspector of schools of Gwalpara and Matia Zonal Primary Education Officer, investigated the matter and submitted the report on 14/12/2023. The inspector of schools has already suspended the assistant teacher of Krishna Higher Secondary School, Muhammad Fazil Haq, based on the report of the investigation officer. The allegation raised against the providence of egg in half parts in this regard, the school principal of the school said that the school had taken such measure because more students had to be given eggs than the estimated number of eggs. Therefore, the school's acting principal and those involved in the midday meal are strongly warned to follow the midday meal policies and guidelines. They are also advised to be vigilant to avoid any confusion in the future. Regarding the construction of concrete shops of 20 numbers of the premises of the school, the investigation officer said in the report that these schools are being constructed illegally on the land of the school. The inspector of school has directed the school authorities to remove the shop on the basis of the investigation report. Therefore, the Gwalpara District Administration has asked everyone not to spread false information on social media and requested everyone's cooperation in maintaining a peaceful and sleepy environment at Krishna Higher Secondary School. This is the report by the Deputy Commissioner also. And thereafter also one further inquiry was made by the inspector of school. There is nothing against me, but only with an assumption that I may not be, my administrative ability has been questioned also. I may not be able to run the school smoothly. And that is why also I have been placed by this impugning order also on the basis of the inspector of schools inquiry report. Page 62 also the impugning order has been passed. I have been relieved from the charge of in-charge principal also. Although there is nothing against me in the inquiry report also, simply on assumption that I may not be able to discharge my duty as a in-charge principal smoothly, I have been my in-charge principal. I have been relieved from the post of IC principal also, by this impugning order also.
Yes.
Lordship, I am praying for notice and Lordship may kindly in the meanwhile Lordship suspend this impugning order Lordship. I may be allowed to continue as IC principal. This order has not been communicated to me Lordship.
Well, assuming that the conspiracy which has been projected by the prisoner is correct, well, the decision for the inspector to decide to run the school is for the interest of the school. The Lordship will kindly find page 60 last paragraph, madam. There, the petitioner may be correct that there is a conspiracy against him, but this otherwise has prejudiced the school, madam. Page 60, my lord, the inspector, thereafter another complaint was received from some local people in connection with illegal collection of fee from the students by the principal in charge and this of the school, and also regarding his academic qualification. In this regard, a hearing was conducted by the undersigned on so and so in the office chamber of the undersigned, wherein the complainant submitted their written statement stating that the educational environment of so and so has been deteriorating due to loose administration of so and so principal in charge of the school. Hence, ma'am, complaints and allegations have been received from different organizations, local people from time to time against so and so. And whereas the question of administrative ability of so and so has been raised by different angles. Hence, it may be assumed that so and so may have to face difficulties in running the school smoothly as he failed to obtain support from all teaching and non-teaching staff of the school as well as local people. Further, the loose administration may also hamper to create a good academic educational environment in the school. And your lordship will see the decision of the director, and therefore the inspector has been given the charge, not any other teachers.
Lordship, may
But
kindly,
we are concerned about the school, madam. There may be dispute between the individuals.
in the earlier paragraph, Lordship, the same inquiry report, Lordship. The Lordship may kindly see, parallelly, the additional Deputy Commissioner Golpara, third paragraph, Lordship, who was entrusted as the inquiry officer about this matter, also submitted a report to the district commissioner wherein it is reflected that during the tenure of the principalcy of Zakir Hussain, the school was running properly and discipline was also maintained in the school. In fact, Lordship, the same inspector of school has given me a certificate. That is a part of the record, Lordship. he has certified me that I have been running the school smoothly. Lordship.
Third, Mr. S.K. Das, non council. Issue notice. Mr. B. Kaushik, and it's nothing council. Secondary Education Department. Affairs correspondence, 1, 2,
1, 2, and 3 million.
1, 2, and 3, and MS B.D. Barman, then an additional semi-government. Affairs correspondence, 4. Notice and respondents are complete, however, extra copies. Respondents are rather collected. Please complete 4 weeks.
Lordship may kindly direct me then status quo, Lordship, as on that, Lordship.
So, well, that will,
Maintain
So are
status
you
quo.
holding the post?
Yes, I am holding the post, Lordship. I am holding the
But-
post of
but
IC principal.
that
This
is the
order,
dispute,
yes.
my lord.
Yes.
He is holding the post
Yes,
and
that-
therefore this.
So if they are holding the post, so Lordship
So
will say
it's
kindly.
not me, my lord, it's
What the director did is, they has given the in charge to the
to
inspector,
the inspector of school.
Inspector of school.
not to any other.
Not to
There is
any
no
other
other
teacher.
If somebody was given, then maybe it is.
Maybe.
No,
maybe.
there is no other teacher having B.Ed degree in the school, Lordship. I am the only qualified
Don't
person.
let the inspector of school run the school at this stage. Let him file the affidavit, after that we'll.
My lord.
Lordship may kindly direct to maintain status quo, Lordship.
No, sir.
My lord, that would amount to a stay.
Lordship may kindly give a returnable date and Lordship will kindly give an observation that my interim
No,
period
no,
will
after
be.
4 weeks, I said, after vacation, I cannot give dates.
Then
There'll be
Lordship,
lot of cases jumbled up.
Lordship,
So it is not coming up on time. You can make your mention, we'll get it.
then that observation may be there, but my interim order will be considered on the next day, Lordship.
Okay, prayer for interim shall be considered on the next occasion.
Obliged.
An improvement of educational environment in Hojai district, the following teachers of lower primary schools are hereby transferred to the schools as mentioned below. Your lordship will kindly look at there's a large number of teachers who have been transferred. 118. Your lordship will just look at the top of the chart. Your lordship will find serial number, then block, name of the teacher, teacher ID, school name, dice code, block to which transfer has been made, and towards the end, your lordship will find the school name. We are concerned here with serial number 32.
Debajit Das.
Devajit Das.
Oh.
He was in Lanka block in Swami Vivekananda LP school, and he has been transferred to Jugijan block, and it's a school by the name of Doboka Nola lower primary school. Now, my lord, these transfers are not like normal transfers made in exigencies of administration. These are statutory transfers. If your lordship will first have, your lordship is aware, pursuant to the 86th amendment, Article 21 capital A was inserted, providing for right to free and compulsory education to children within the age of 6 to 14. In terms of that, the parliament enacted the Right of Children to Free and Compulsory Education Act 2009. If your lordship will kindly have the act. Please read one. The whole idea behind this act was to have not only provide free and compulsory education to children, but also to have proper education of children. And for that matter, there are some statutory provisions made. If your lordship will first take up section 19.
Yes.
Section 19(1). No school shall be established or recognized under section 18 unless it fulfills the norms and standards specified in the schedule. So these norms and standards have to be met. Now, if your lordship will kindly turn to section 25.
Yes.
Pupil teacher ratio, subsection 1. Within 3 years from the date of commencement of this act, the appropriate government and the local authorities shall ensure that the pupil teacher ratio as specified in the schedule is maintained in each school. Now, if your lordship kindly turns to the schedule.
What's the schedule?
Schedule should be, if we are holding the same book, it should be at page 21.
Yes.
What the schedule provides is this pupil teacher ratio, what is known as the PTR. And your lordship will find at A, subclause A, for class, first class to fifth class, the ratio is given. Admitted children and number of teachers, up to 60, 2 numbers, between 61 to 90, 3 numbers, between 91 to 120, 4 numbers, between 121 to 200, 5 numbers. We fall in, this particular school from which I have been transferred falls in this category because if your lordship will take up, this violation itself should suffice. If your lordship will kindly turn to, we have given the quota slate a ratio, Amar school ratio to page 29. This is page 29 of the
petition.
of the writ petition. There are several violations. I am showing the first basic violation, which violates the act itself. Annexure D at page 29. Your lordship will find this is a printout of the website, Swami Vivekananda School from which I have been transferred. Now, if your lordship will kindly turn the page to page 30, in the middle, your lordship will find total number of teaching staff, 5, and total number of students, 142. So the moment I am transferred out,
This is in which school?
the school from which I have been transferred,
Swami.
Swami Vivekananda School. So the moment I am transferred out, the ratio itself gets violated, which is a statutory ratio. It will fall to 4 numbers, and the requirement under the act is that between 121 to 200, there has to be 5 numbers of teachers.
Anybody coming replacing?
No
you?
one. I am not replaced. In fact, my lord, there are various other aspects also. If your lordship will, pursuant to this, my lord, not only the act, Assam has framed an act which is known as, because now it has become a constitutional mandate. So the state of Assam has enacted an act which is known as the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2020. This act, if your lordship will kindly have the book, here you can, manual.
Yes, page.
If we are holding the same book, it is at page 8 one. Has my lord got it?
Yes,
Your lordship will straight away turn to section 3.
yes.
Norms for posting of teachers. All teachers of elementary schools shall be posted by the appointing authority strictly in accordance with the provisions contained in the Right of Children to Free and Compulsory Education Act 2009. Then subsection 3, your lordship will find the place of posting of teachers under subsections 1 and 2 above shall be in accordance with the PTR norms as laid down under section 4 of this act. PTR is that pupil teacher ratio. For section 4, small a, for elementary schools, PTR has to be calculated in accordance with the provisions contained in sections 19 and 25 read with the schedule of the Right of Children to Free and Compulsory Education Act 2009. So this act also for transfer and posting provides for this. And if your lordship will kindly turn to section 5 to regulate this, subsection 5 of section 5, to regulate these transfers and postings, this is what the act provides. The district level committee, as mentioned below, shall be the competent authority for recommending inter-school transfer of teachers within the district. The committee is provided for. And then subsection 6, the appointing authority shall issue the inter-school transfer order of teachers within the district on the basis of recommendation of the district level committee on being satisfied that the recommendation is made in accordance with the provisions of section 4 of this act. In the present case, my lord, our instruction, specific instruction is that there is no recommendation by any committee. Now, if you're under these, there's a provision for framing of rules. They have framed rules also, which we have annexed to the writ petition itself. Your lordship will find the rules at page 32. Page 32.
Yes.
These rules may be called the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Rules 2022. And if your lordship will straight away turn to Rule 15. Page 53.
Yes.
We are not concerned with sub-rule 1 of Rule 15 because it pertains to schools with only one teacher, not sub-rule 2. The inspector of schools in case of secondary schools, we are not concerned. And the DEO in case of elementary schools in the district shall ascertain the number of teachers, tutors vis-a-vis the pupils teacher ratio in the elementary schools and the subject-wise students as well as the PTR norms in the secondary schools. It shall be authenticated with the available UDIS data maintained by SSA so-and-so on the basis of the findings. Next sub-rule 3. On the basis of the findings, the inspector of schools shall prepare a list of schools having excess teachers, tutors as per pupil teachers ratio norms, subject norms in secondary schools. The district elementary education officer in the case of elementary schools will prepare a list of schools having excess teachers, tutors as per the PTR norms. Similarly, both the officials shall draw up another list having less number of teachers, tutors as per the PTR, etc. norms. The respective elementary and secondary education department shall examine the list school-wise and transfer the excess teachers, tutors to the schools having less teachers. So only in case where there are excess teachers, they may be shifted to schools where there is a shortfall of teachers. Now, in terms of these act and the rules, there are two notifications issued which are also relevant. The first notification is at page 24.
Yes.
So immediately after notifying the rules, this notification was issued at page 24. It reproduces the entire rule provisions of Rule 15. Your lordship will find in the middle of that page, excerpts of the provisions are reproduced below, the rules that I placed just now. And if your lordship will kindly turn the page to page 25, last paragraph. The deputy commissioners of the districts, excluding the 6th schedule district and BTC, shall give effect to the provisions of the Assam so-and-so rules 2022 as above in respect of rationalization of teachers with immediate effect and until further orders. So what has been notified is that you will strictly comply with Rule 15. And there is another executive instructions that in fact, this also has statutory force. If your lordship will kindly turn to page 55. So I'm not troubling your lordship with, it's a very longish OM. Basically, what has been said is, this is to give effect to the Act of 2009. And towards the bottom of that page, your lordship will find para 2, PTR in LP and UP schools, considering the minimum enrollment as 30, the parameter prescribed in the schedule of RTE Act shall be strictly followed. And this OM itself, if your lordship will kindly turn to page 58, prescribes the procedure to be followed when transfers are to be effected. And we are concerned with some of the notified clauses, principles, my lord, to be followed. Page 58, your lordship will find the heading rationalization of teachers and posts. We are concerned with, firstly, 10, subclause 10. The district level committee constituted under Rule 55 of the Assam Elementary and so Rules 22 shall be the competent authority for rationalization within a district. Now, 14, sorry. The first attempt will be to rationalize the teachers within the block area to minimize dislocation, and then with the district. Now, your lordship may turn the page, clause 19. While rationalizing in a particular teacher category subject-wise, the most junior teacher in terms of tenure in service shall be transferred. And then 12, both committees should ascertain the medium of school. So there might be a Assamese medium, there might be a Bengali medium, there might be a Hindi medium. So these mediums have to be maintained to be covered under the rationalization process of teachers. Now, in this particular case, besides the statutory violation that I pointed out, what has happened is this. It says that the junior-most teacher, in case transfer is necessary, it should be the junior-most teacher to be transferred out. Your lordship will kindly come to page 64. And your lordship will find that out of the 5 teachers in the seniority list, I am at serial number 3. There are 2 other teachers who are junior than me. If at all they had to transfer, assuming it would have been permissible under the Act, even then they could not have touched me before touching serial number 4 and 5. And thereafter, it says, the provision says that the medium of the school has to be maintained. I was earlier posted, Vivekananda School is a Bengali medium school. Now I have been transferred to a Assamese medium school. That is a categorical statement we have made at paragraph 7 of the writ petition. Then there is another clause, clause 14, which provides that it should be in the same block. Now, if your lordship comes back to the impugned order, I am at serial number 32. I have been transferred from Lanka block to Jugijan block. I could have still understood had no other school been available in Lanka block. If your lordship, interesting thing, if your lordship will kindly turn to page 67. There are several. Serial number 59 is a person who is again transferred from Jogijan to Lanka, which means there was a post available in Lanka. Then, if your lordship will kindly turn to page 68, your lordship will find the same situation. Serial number 69, 70, and 71. Again, people from Jogijan have been transferred to Lanka, which means there were vacancies available in other schools in Lanka itself. Similar is the position in page 69. Serial number 89, 91, 93, 97, 98, all Jogijan to Lanka. So therefore, my lord, not only has the statutory provision been violated, their own statutory instructions that have been issued towards implementation of the Act, that also stands violated on several counts. So therefore, my lord, in my respectful submission, my lord, your lordship will issue notice and stay this insofar as there are several. So I'm praying for a stay in respect of me, my lord, because there is no one else who has been transferred in against me. So that is why we are alleging violation of that ratio also. Your lordship will stay this. So far as serial number 32 is concerned.
No, this basically is not a regular transfer. It's a process of rationalization. Your lordship will find page 24, the notification.
Page?
Page 24. Second paragraph, my lord, will find. In case of a school within the district having a single teacher, tutor, or no teacher, tutor, or shortage of teacher, tutor due to any reasons or circumstances, at any point of time in elementary schools or secondary school, the respective district elementary officer or inspector or any administrative authority shall within a period of 36 hours with the approval of the deputy commissioner of the district shall transfer, shift, and post require the number of the tutor teachers to the single teacher, tutor, or no teacher, and they maintain the PTR in the elementary schools in the particular subject as well as PTR as per norms and the secondary school. The exercise of rationalization of teachers shall be done throughout the year on the need basis. So, my lord, the school, possibly, my lord, the school to which the petitioner has been transferred, that may be the school which has no teacher. And this basis, my lord, we are required to maintain the PTR, not just in that the petitioner schools, but in the other schools also.
But
And
are you
this-
not supposed to transfer on the recommendation of the district level committee?
My lord, this the
That is what your act provides.
Act of 2020. But if your lordship finds this notification of 13 December 2020 was issued under section 14 of that act, my lord. And your lordship will find page 25 now.
Section?
Page 25 of no, page 25 of the petition. The notification. The second,
Yes.
before that, my lord, will find page 24, last paragraph, my lord. The line starts from district elementary education officer in case of elementary schools. My lord finds page 24, last paragraph. The line starts from district elementary education officer in case of elementary schools will prepare a list of schools having excess teachers as per PTR. Similarly, both the officials shall draw up another list having less number of teachers as per the PTR. So it is the list which is prepared by the DO, and the power of the transfer has been given to the deputy commissioner, page 25, last paragraph.
Yes.
Yeah. So had it been a case of regular transfer under the 2020 Act, my lord, then the recommendation of committee will have to be applicable. But here, my lord, it's not a case of a regular transfer. It's a rationalization, the process of rationalization to meet up the schools where there are no teachers and no
See, that's fine. That's
Well-
fine. If you are trying to meet up the schools having no teachers. But then when you're doing the rationalization,
my lord,
the school in which the petition is teaching,
my lord.
that school is suffering because that school was having 5 teachers in terms of the schedule to the to the Act of 2009. Having an enrollment of 140,
142.
142.
And the
Now,
statutory
if
requirement.
you've taken one teacher out, you've not sent the replacement.
Hello?
Then the teacher people ratio will be.
Well, because the petitioner has been transferred to that school, that will also have to look into whether that school has to.
But no, that's fine when you're looking into that school, but then when you're transferring them out from
That-
this school,
Yes.
that school, this particular school is suffering.
Well, for that,
The-
my lord, government will.
PTR is now no more there.
My lord.
In
Well,
terms of
that-
the
if-
schedule.
If there is no teacher in that school, this rationalization has been done in a need basis, my lord. Now, if there is no school, if the PTR is not maintained in the petitioner school, then government will look into in that aspect, my lord. It's a temporary arrangement for getting to run that school, my lord.
That's fine, that's fine.
And supposing,
Trying to
madam,
run that
I
particular
understood,
school.
madam, what your lordship is saying that if the school where the petitioner is working, that school also require 5 teachers. And now if the petitioner has been taken out from that
Without replacement.
that, my lord, government will take decision in respect of that, my lord, to maintain a PTR in that school. But for that, my lord, petitioner cannot be agreed for by this transfer, my lord.
Yeah.
Because it's otherwise, my lord, this process of rationalization has been done with an object that the schools which has no teachers at all.
That we'll see.
And this, my lord, And the process of rationalization has been done after a thorough exercise. Thorough exercise by the district elementary school teacher, education officer, by preparing list of teachers which has teachers and which does not have at all teachers. And in this rationalization process, it is going on throughout the state. We are doing this exercise since a long while. This is a notification of 13 December 2022. In fact, if your lordship finds this in this notification, page 24, within a period of 36 hours, we were supposed to do it. But as this process, which requires time, and we have done a thorough exercise of finding out the teachers, these schools which are suffering because of no teachers.
Now, how do you say that this school has no teachers?
Well, that for that we'll have to take instruction because
That's what you're just submitting from nowhere.
no, my lord, the notification
You have to show us that this
No,
school does not have teachers.
if your lordship kindly finds page 25, the page 25,
Yes.
first paragraph, third line, my lord, start with in case of school having a single teacher, tutor, or no teacher, the prescribed PTR shall be maintained in the particular school by ensuring posting of teachers through transferring and shifting.
Where's that? Where's that?
My lord,
Page 25.
page 25.
Which para?
My lord, the first paragraph from bottom third line, my lord, the line starts with in case of. Well, that's the object of this notification, or that's the object of the rationalization.
Then what happens to the other school?
My lord.
What happens to the other school?
Well, that possibly the government when has taken a policy decision of rationalization in this manner.
See, this is what the
And this policy is
Act
not on
of
the challenge.
This is what the Act of 2009 says.
My lord.
No, they're not challenging the Act. They're saying
Yes.
that you have done it in violation of the Act and the rules
No,
and the office memorandums.
my lord, the office memorandum, this transfer, if your lordship will see the transfer order, my lord, the order which is imputed here. Page 65, my lord.
No, 26/2024.
Yes, it was, this is an order passed under the notification 13 December 2022 and in exercise of the power under 28/11/2022, which empowers the district commissioner to pass the order.
Where is this?
In pursuance of the revised notification, right, my base page 65. In pursuance of the revised notification dated 13 December 2022, issued from the Secretary to the Government of Assam, in exercise of powers conferred to the District Commissioner by notification dated 28/11/2023, in the interest of public service and improvement of the educational environment in Hosai district, the following teachers of the LP school are hereby transferred to the schools as mentioned below. Now, your lordship finds this notification at page 24, which I am relying on. This notification does not provide, my lord, as it is provided in the Transfer Act 2020. That had it been a case, my lord, it is a transfer under the 2020 Act.
Kaushik, you're going wrong.
My lord.
First Act of 2009 was enacted. On the basis of this Act, 2020 Act, Assam Act was enacted.
Rules.
On the basis Act, 2000, then you have your rules.
The
In
Assam,
terms of the rules in the Act, you brought out this notification.
see, Assam Act, my lord, is referring to that 2022. That is, my lord, Assam Elementary and Secondary Teachers Regulation and Posting and Transfer Act 2020. That is for the purpose of regular posting and transfer from secondary and elementary schools. For that, my lord, we have a specific committees which will recommend, and after the committees recommend, then the transfer and posting is acted upon, my lord, as per the Act. Here, this, my lord, the rationalization has been done under the page 24 notification. And this notification issued under section 14 of the Act of
Rules. Under the Act of of
2020 and Rules 2022.
You framed the rules.
Yes.
And in terms of the rules, you brought out this notification.
Correct.
then how can you go against the act and the rules?
No, this notification, your lordship, is see, this notification is for the purpose of the rationalization. Not a regular transparent posting under the 2020
Okay,
Act.
you file your affidavit.
But if your lordship, if the only concern is this rationalization is going throughout the state, my lord.
I'm not saying the whole notification.
Ultimately, it will open the floodgate, my lord. Because if an individual prejudice is looked into in the terms of the rationalization, my lord,
Not only the individual producer, I'm not going into that. I'm also looking into that Swami Vivekananda school, where the enrollment is 142 and they require 5 teachers. You've taken out 1. Now they're left with 4.
then my lord will take day after tomorrow, my lord. Let me have the instruction, my lord, as to what decision the government has taken with regard to the schools where from the teachers has been taken up. Because otherwise the schools where they have been taken to, my lord, these schools, if they don't have the teachers, my lord, this is a process only for the purpose of taking care of that school, my lord. With regard to the maintaining PTR in this petitioner school, what decision government is taken?
This is the issue.
Yes.
See, you're trying to see that one school where there are less teachers, that is taken care of. In the meantime, you're depriving another school,
No.
taking out 1 teacher, and the PTR is totally
My lord,
gone.
let us take the instruction, my lord. We'll take up on Friday, my lord.
Okay, fine, that's fine. Fair enough. We'll give you time till
My
Friday.
lord.
Let him come on Friday.
We'll also find out, my lord, what is the PTR, my lord, both schools, my lord. The enrollment of both schools.
Very submission is contradictory because the 2020 Act says that 2009 Act, Section 19 and 25 along with the schedule should be strictly complied with while making any transfer. And in terms of that Act, these rules have been framed. Now, page 24 notification is issued to implement the provisions of Rule 15. And in that context, in fact, when the power has been conferred on the Deputy Commissioner, the government is very particular in saying that it has to be in terms of the rules of 2022. If your lordship peruses page 25, last order, where the power has been come. So it is not that they can, while making any rationalization, they can be oblivious to the Act of 2020 and the rules of 2022. So therefore, the very argument is self-contradictory.
In respect of 2009 PTR, my lord, there's no dispute. We'll have to maintain. There's no dispute to that. But here, my lord, your lordship will kindly appreciate one thing. It is a decision to see also that which school is suffering more, my lord. If there is a school which have at all no teachers, and if there is a school which has 5 teachers.
So when you're trying to see that one particular school is taken care of, are you trying to violate the statutory
No,
requirements?
exactly. No,
Exactly. That is the question.
But that government always have an option of replacing.
Government don't have the option to violate statutory
No.
requirements.
My lord, what I'm saying is, we have initiated lots of recruitment process in the last few months, my lord.
That we understand. That we
And
understand.
suppose,
What you're
sir-
trying to do, we appreciate what you're trying to do. But then sometimes when you're trying to do something, you may be missing out on something else. And this is what is being projected in this writ petition.
Yes, let me find out, my lord, what is the enrollment of this petitioner school? Both the schools, my lord. Where the petitioner was working and where he has been transferred.
Okay. But Mr. I. Chowdhury, Learner Senior Counsel, to petitioner. Learner Senior Counsel assisted by Mr. A.K. Barra, Learner Counsel for the petition. Stop. By this writ petition, the petitioner is challenging the order dated 26/2024, by which he has been transferred and posted, transferred or rationalized.
Transferred. The word they are using is transfer.
Yeah, where he has been transferred from the Swami Vivekananda LPS of Lanka Block to Dapoka Nala LPS of the Jugijan Block. Stop. The case of the petitioner is that that his transfer has been made in violations of the requirements of Section 19
and 25 of the right to, right with the, right with the schedule. Schedule amendment of the right to children, right of the right of children to free and compulsory education Act 2009. Stop it.
And also in violation of the OM dated 5/5/23.
The further case of action is that the government of Assam has enacted the Assam Elementary and Secondary School Teachers within bracket regulation of posting and transfer Act 2020. And the transfer of the petitioner has also been done, has been made. Which section was it? In violation of
Sections 4, 5, 3, 4, 5.
section 3, comma 4, section 4, and section 5 within bracket 5, correct?
Mal.
Of the said act. Stop. It is the further case of the petitioner that in terms of the, on top where I said the act of 2020, we just put within bracket act of 2020 in short. That the government of Assam has also framed the Assam Elementary and Secondary School Teachers within bracket regulation of posting and transfer rules 2020. Stop. Where it, where it, rule 15 provides for the rationalization, shifting and transfer of teacher public tutor for administrative executions. Stop.
For giving effect to the Act of 2009.
And also to give effect to the act of the act of 2009. Stop. Para. Where's that OM?
OM is that, my lord, page 55.
It is also the case of the that the transfer of the petition is in violation of the provisions of the office memorandum dated 5/5/2022 issued by the Department of School Education. And the other one,
The other one is at page 24. One.
uh,
This OM is for the purpose of rationalization only, if your lordship sees the heading.
of 5/5/2023, huh? Which provides for rationalization of teachers and post of teachers. And the notification dated 13 December 2022 issued by the Department of School Education. It is also the case, it is the case of the petition that the school in which he has been serving, the word that Swami
Page 29, man.
the Swami Vivekananda LPS. There is an enrollment of 142 students. And the total number of teaching staff is 5. Therefore, as no replacement has been given, has been sent due to the transfer of the petitioner, the PTR as provided under the Act of 2009
Is valid.
stands violated. Stop. Para. Mr. B. Kaushik, the standing counsel, elementary education, prays for time till Friday to enable him to receive instructions. The prayers allowed, list the matter on 28 June. 2020.
Till then, let them not pressurize me. Let status quo as on today be maintained, which your lordship will reconsider on.
Till the next suitable date, the parties are direct maintain status quo as of.
The next two items are also identical, my lord.
Which school?
Schools are different. Schools are in the next item. Serial number 104. Serial number 104. He has been transferred from 104, 106.
You just change it.
At page 70, item number 60
1 minute.
is serial number 104.
Same notification, page number
70.
70.
104 is the petitioner in item number 60 and serial number 106.
1 minute. This item 60, you say he has been transferred from one number Lankeshwari Grant LP School of Lanka Plum to Alipu LPS of
Say-
of
He is in the same block.
of Lanka Plum. And then
One-
where's that ratio PTR? Have you annexed? Have you annexed?
Here, my lord, issue is not PTR. Here, issue is seniority. The OM provides that the person who is the junior most should be transferred. Here, he is one of the senior most. Second is Bengali medium. And he has been sent from Bengali medium to Assamese medium. So here, the act has not been violated as such. Here, the OM of 5523 has been violated.
Then I have to change the whole order.
Here, that act portion, your lordship can omit.
You omit.
Only the
that
OM of
transfer has done in violation of the OM dated
5523.
page in this.
Page 56.
OM dated 5523 issued by the Department of Education on the issue of rationalization of teachers. Particularly clause, which clause?
Here, clauses are two, my lord. Page 50. Clause 19
Clause 19.
and 19 and 22.
19 and 22. huh? The case of the petitioner is that he is the senior most teacher in the school, correct?
Yes, he's the senior.
Senior most teacher in the school.
Next case to please.
And instead of transferring the junior teacher, he has been transferred by the said notification. Dated 26, 2026. Then next case.
In next case, my lord, Sumesh Paul, he is at 106, serial number 106. And here also issue is that there are three persons junior than him. But I have been touched. And again, from
Lanka. Here you say, yes.
schools are
Number one, that's from where the petitioner has been transferred from one number Lankeshwari Grant LP School of Lanka Block to Palipata Jurapukri LPS of Lanka Block. Here also seniority.
here also senior.
CA persons are with the same thing as the.
Yeah, Peter.
So possibly in the other two cases, the PTR issue is not there. Yeah. So I'll have to take instruction, my lord, whether all the teachers are regular teachers, because the petitioner appears to be a contractual. All teachers are contractual.
All contractor.
I'll take. And the order of status quo in the other two also.
Oblige.
14 of daily list admission.
Your lordship. Your lordship, here the petitioner has filed an application for compassionate appointment under dying harness scheme. As his father died on 2nd of January 2007, and he applied on 31st of August 2007. And
When did your father die?
2nd January 2007,
2007. When did you apply?
31st August 2007.
Then
After that, your lordship, what happened? His application was forwarded to Deputy Commissioner through Inspector of Schools, that is respondent number 8. And it was kept pending. Much prior to that, the petitioner has filed a writ petition before this honorable court where he got a order in his favor. That order is annexed here.
which
Page number 22, annexure A.
oh,
Where a direction was given, your lordship.
yes, then
And since then, as the matter was kept pending, to know about the whereabouts of the matter, he submitted a pleader notice. Pleader notice was submitted on 2017 to know about the whereabouts of the matter. When he submitted the pleader notice, in response, he got the information that his application was rejected. The DLC rejected his application without any reasonable cause. And interestingly, your lordship, what happened? The private respondent number 13, whose father died in the year 2009, his name was got recommended, and the petitioner's name was not recommended.
yes, who appears?
I'm appearing for the secondary education department, your lordship. Lordship. Here, I think lordship, this government has to appear, your lordship.
Government has to appear. Where's the government duty? Any instructions? 2019 matter.
Your lordship, one thing I have to mention here, in annexure G, page number 42, I have annexed an order of this honorable court. It is a covert case, your lordship, where a similar situated case. The same order was passed.
Yes, duty.
Lordship, 2019, lordship, our brief is not there. That's. Can it be taken on Friday?
It took you so long to say that your brief is not done.
Lordship, may it be taken on Friday?
Not Friday. Friday I've listed many cases. I'll give you after the vacation, you come with appropriate instructions. Otherwise I'll pass on.
Yes.
But Mr.
NC Kathazorika.
NC
Kathazorika.
Hazarika and the council. On request made by Mr. B. Theory and the government. Is the matter. immediately after the summer vacation. We enable this.
Much obliged.
15.
My lord, kindly have a look at the last order, my lord. If since long, my lord, I am fighting to get back the, my lord, DCRG amount which was illegally deducted from me. And in spite of their all admission that there is a mistake, my lord, from the all the respondents.
Finance,
Finance also saying, my lord, they have nothing to say because this is the authority ultimately who did director, my lord. They have filed the affidavit.
Of the AG, my lord, we have nothing to do.
what appears for the secondary education?
Is a
You approve?
Lordship. Can it be taken after some time, Your Lordship?
well, it is an admitted take, my lord. It is nothing to take more time because the everything is there.
Kaushik, Mr. Vedanta Kaushik will be appearing in this case, Your Lordship. After some time, he's here, Your Lordship.
After some time, it will be difficult because
This court is rising at 3. I have an interview.
my part also not a rule because my election is going on. Even then, I am appearing for lordship, my lord. So, so I had to be disposed of, my lord. It is nothing to, my lord, say anything by the director because the everything is
The
okay
problem
from
is, I'm having paucity of time today.
my lord. But then, well, immediately after vacation, my lord, that may be on.
Mr. B. Martha, and the council. On requestment, the MS.
B. Musahari,
Misharil and the standing council.
Secondary Education
Secondary
Department.
Education Department.
বন্ধ কেটে রেখে আছে
Or
15 16 at Blue.
or
My lord, 16, my lord, 16 July.
16.
My presence may be recorded, my lord. B. Sharma on behalf of AG.
Standing council. Address to the accountant general for the- And Mr.
I didn't know what it
Incident and council.
Police, My lord, I have a prayer, my lord. The another matter 23, that also mine belongs to me. But that may be taken after the vacation also, my lord.
On requestment by B. Martha and the council.
It's the same day, my lord, on 16, my lord.
This after the, I'll say after the summer vacation.
But summer, yes,
If
6,
it does not come up, you can make a mention.
but I am not available from 17 to 22, my lord. So that's difficult. If it is coming,
Let it come up.
then after 22, my lord.
I'm not fixing the.
Masterpiece.
17.
Obliged.
My lord, this matter may be taken after vacation, my lord, along with the affidavit filed by me on yesterday, my lord.
What affidavit you have?
A reply affidavit, my lord. Perhaps it is not on record, my lord.
Mr. A.H.M.R. Chowdhury, legal counsel for the petitioner submits that he has filed an affidavit in reply on 25th
Yes, my lord.
June. Stop. We just need to verify and place the same on record, list after this summer.
Deeply.
Lordship. Lordship, I have a prayer with regards to item 40 to 42.
Huh?
40 to 42.
Yes.
I have a prayer.
Yes.
Lordship, a date may be fixed. If there is a paucity of time today, a date may be fixed
After vacation.
after vacation, Lordship.
You have for your good name?
My good name is MS Sabina Ahmed, Lordship.
Okay, on request by MS Sabina Ahmed, the counsel for the petition. Please come after on. When do you want?
Lordship, immediately after the vacation,
22nd.
Lordship,
No. I mentioned.
obliged.